Management, item number 51, WPC 5771 of 2021.
Petition allowed.
Item number 52, WPC 471 of 2024.
Petition partly allowed.
May I please your lordship. I beg to mention item number 3 of the daily list today's list.
Item number
3, lordship. In this case, lordship, senior counsel Mr. P.J. Mohanto is appearing, but some personal difficulty he could not appear, lordship. So, lordship may kindly adjourn the matter for today and fix the lordship on 20 or 23, lordship.
Item 3, my lord. Your lordship directed us to file one additional affidavit. We are filing it during the course of the day.
okay. Mr. Your good name, please.
C. Bhattacharya.
C. Bhattacharya. Learned counsel appearing on behalf of Mr.
T.J.
T.J. Mohanto, learned senior counsel for the petitioner. With consent from the other side, as for listening the matter on
20 or 23, lordship.
26th.
Grateful.
Lordship.
I'd like to mention item number 26, your lordship.
26.
Yes, the matter of author for the day, lordship.
26.
Yes, sir.
When to be listed?
After 2 years, sir.
Pardon? After 2 weeks.
Yes, sir.
Mr. Your good name, please.
That's right.
Learned counsel for the petitioner with consent from the other side, as for listing the matter after 2 weeks. Fair.
May I pray, your lordship? I beg to mention regarding item number 31 of today's list, lordship.
Yes.
It is the bail application, lordship. Can it be taken up at 2, lordship? I have informed the PP regarding this, lordship, that I am making a mention before the court.
Okay.
Oblige, lordship.
May I please your lordship? On the consent of the others, I beg to mention item number 28 of today's list.
28.
28. Affidavit has been sent for vetting. Kindly the matter may be taken after 3 weeks.
Lordship, I appear for the petitioner in this case.
Your good name, please.
M. Bora.
M.
M. Bora.
Is M. Bora, learned counsel for
Respondent number 1, 2, 3, 4, and 6.
respondent number 1, 2, 4, and 6 with consent from the other side. Press for listening the matter after a week.
After 3 weeks, my lord.
Why 3 weeks? After 2 weeks. Okay.
Some date being fixed, your lordship.
Okay.
I'm for UPSC on
3 weeks.
You are for?
UPSC on behalf of Dr.
On behalf of?
Fine.
Okay.
After 3 weeks, lordship. On 6th June.
Highly obliged, your lordship.
May I please state, lordship? Lordship, I beg to mention item number 1, lordship. To engage the advocate is out of his station.
After?
Matter may be adjourned for the day, lordship.
For the day. Mr. Your good name?
J.I. Mandal.
J.
J.I. Mandal.
J. I. Mandal, learned counsel.
May I please, your lordship?
On the request made by Mr. J. I. Mandal, learned counsel for the petitioner, the matter stands adjourned for the day.
Lordship, here in this matter, lordship, I'm sorry. In this matter, the proposal which was sent by the DO to the director, that a report has been sent to the government, lordship. Therefore, it will take some time. May I place the report also?
Item number 1, no?
Therefore, lordship, I fix after 3 weeks, lordship, because that report has been sent to the government for doing the needful. This is
After 3
regarding that retrospective benefit of this grateful staff.
Okay. After 3 weeks.
After 3 weeks, lordship.
May it please, your lordship. Lordship, I beg to mention for listing where IA lordship. It is a part matter, lordship, connected with petition. Listed before your lordship tomorrow, lordship. Finance department will sought to be impleaded party respondent. Mr. Soliha is already appearing in the case as per direction of your lordship, and we have also served a copy. But formally, the Commissioner and Secretary Finance Department should be impleaded.
Okay.
Obliged.
Item for personal appearance, item number 32.
As per lordship's directions, our officer is present here, the Joint Secretary of Higher Education Department, as well as Register of Dibu University also present here, Lordship.
Okay,
And they have a talk day before yesterday, Lordship, regarding that part.
yes.
Dibu University is an autonomous institute, Lordship. It is run by the grants in it given by the government. Lordship.
Hmm.
There is no separate pension head in respect of the Lordship, the regular pension as well as area pension.
Hmm.
So they have the utilize the funds from the grants in it, Lordship.
Hmm.
Accordingly, government instructed them to Lordship utilize the fund from the grants in it given to the Dibu University. And they have moved the treasury with a rupees of 20 crores for release the Lordship, the area pension part.
Hmm.
Lordship. It's a Lordship installment wise, Lordship. As a whole, it cannot be Lordship. So as per court soda also Lordship, courts have directed us to as the installment give the area pension Lordship. And that's why they have proceeded proposal Lordship yesterday.
Yes.
Yesterday they have approached the treasury officer concerned Dibugo treasury Lordship to release the 20 crores. Lordship. This is the present stage Lordship.
So when the amount will be credited in the accounts of the.
Amount will be
finance?
credited Lordship. It will be up to the finance Lordship. Already they have approached Lordship. Already they have approached as and when it was released by the Lordship treasury, then it will be go to the concerned person account Lordship.
No. When the treasury will complete the process.
Treasury part today, the treasury, it will take 2 or 3 days. Lordship.
Within a week, Lordship, the payment, once the treasury officer receives the bill, Lordship, then they can just process it within a period of 1 week. 1 week to 10 days, depending on the number of days, but the process will start within 3-4 days.
So how much time you will take to make payment of the
Release the
entire amount?
payment. Release the payment.
Entire amount.
Entire amount Lordship, it will take time. It will.
No, take time. You cannot raise the matter indefinitely.
I am not saying that Lordship. I am not saying that. It will amount to Lordship more than 100.
No,
Lordship.
take time means you have to definite time frame. that in
Definitely,
this period we will-
that's why I will place it before Lordship.
Hmm.
It goes to area salary in amount around 100 crores rupees Lordship. If 100 crores is utilized as a time Lordship, then it will be difficult for the part of the Dibu University to utilize the regular salary as well as regular pension also Lordship. If that part is given, even the regular pension and regular salaries of the university employees will be hampered Lordship. So Lordship, it will give a within a 4 installment Lordship equal size 20 crores Lordship. Subject to the release fund by the finance, the Lordship may indicate finance part also Lordship.
If a lordship should kindly come to the operative direction of the Honorable Single Judge Millard at page 57 of the contempt petition. Para 5. On receipt of the budget estimate, government will provide the budget either as a grants in aid or in appropriate column as it deemed fit without any delay. In the alternative, in case of extreme fund constraint, government is also given liberty to release the first regular family pension monthly to all the eligible retired employees. Prospectively, they are paying Miller, that we are not saying no. And to release the arrear pension by of adequate installments. So, my lord, this was in 2021. And today we are in 2025. So on at least 40-50 occasions, the matter has been listed, my lord. Every time the contention is, we have released the fund, Dibrugarh University should do it. Now what transpires is Dibrugarh University doesn't have the adequate fund. That is the main problem. Dibrugarh University cannot generate fund, my lord, unless grants in aid come from the state. Where from Dibrugarh University will generate these funds? Therefore, it is the obligation of the state to provide the fund, maybe in the form of a budgetary allocation, maybe in the form of a contingency fund, maybe in the form of a supplementary budget. But fund has to be given by the state. All along, my lord, kindly see how many instructions have been placed both by finance and higher education department. So, my lord, as far as we are concerned, we are not shuttlecock. As far as we are concerned, my lord, we are on the verge of dying more. Many people have died. And my lord, today, and my lord, out of the entire lot, 127 has not even claimed. That way their financial. Total members 423.
My lord, there are 423. Today we have received one instruction, my lord. 294 has only claimed. 129 have not even claimed pension. Because their claimants are either not there, somebody has died, nobody is there, something like that. So their burden has been there.
a decrease substantially. Because out of 432,
423.
423, now only 298 claimants are there. So, my lord, my humble submission is within a week from today, the first installment of the area payment should be cleared. It is their headache, my lord, how they arrange it. Lordship will pass that.
I'll
order.
clarify also. I'll clarify also. Regarding fund allocation, Lordship, the proposal was come from the concerned authority of the Dearness University, Lordship, 161 crores 13 lakhs for the financial year 2024-25. Accordingly, government has sanctioned 150 crores 72 lakhs for that financial year. This is the grants in it. They have to utilize the funds from that fund. So first installment already they have processed 20 crores rupees to the treasury officer. It will Lordship within a week period, they will process finance council already stated Lordship.
Then second, third, and
Second,
fourth
third
installment?
Lordship, it will next another within a other 2 months period Lordship will provide. Within this year Lordship will complete the process.
All right, my lord, Lordship will
Within this
monitor
year-
this. Let
within
the
this
matter
year-
be called
within
on
this
next
year-
Monday
Within
or
this,
Wednesday, my lord. Let
Monday,
us see.
Monday,
Or Wednesday, because 7 days. Today is Wednesday.
this is not the issue, Lord. Lordship, if he posted it after 10 days, Lordship, in the meantime, they will get Lordship. It is not an issue that after 2 days or 3 days, matter will be listed that the work will be not done, then nothing will happen, Lordship. Lordship may posted it after 10 days. In the meantime, that process will be done, Lordship. Regarding first installment process, Lordship. And whole process will be completed within the period of this year, Lordship. The whole financial year budget is Lordship 161 crores 39 their demand, and it government has Lordship 150 crores 72 lakhs Lordship. So it will be done Lordship in this year.
No, my lord, then why the Dibrugarh University did not raise the bill earlier if money is lying?
That is not the issue, Lordship. The budgetary proposal is 161 crores 39 lakhs. Government allocation is 150 crores 72 lakhs. It is not a mean that as a one-time Lordship that amount will be released. It is not the issue, Lordship. It's a the grants in it also release installment wise, Lordship. As per their Lordship utilization. Whole functions are done by particular date grants in it university, Lordship. They have not individual income loss. Otherwise, the autonomous is not only Dibrugarh University, Guwahati University, other state university, all are Lordship as per grants in it, Lordship. We are doing loss. It is not that Lordship we are not doing loss. So Lordship may posted it after 10 days. In the meantime, they will do Lordship. And other parts within a period, within this financial year, it will be completed.
So let it be called on next Wednesday, my lord, 7 days from today, and let us see,
Lordship,
my lord,
after
how
10
things
days,
progress.
my lord may posted it after 10 days, Lordship, will come with a positive instruction. 7 days is not a period, Lordship.
Third, Mr. Ken Chaudhary, Senior Counsel, assisted by Mr. So for the petitioner, and Mr. Gogoi for respondent number 1, and Mr. Goswami for respondent number 2. Mr. Goswami, you are for the respondent number 2.
Hey, Goswami.
He's for 2 loss.
Respondent number 2.
Otherwise,
Connection.
earlier incumbent is not holding the post. Even registry also new one and commissioner also new one loss. Earlier incumbent is 2 or 3 years back they have gone loss.
These are all technical pleas, my lord. End of the day, this pension has to be disbursed. These are all
Otherwise,
technical
that
pleas.
is also required loss.
Connection with a letter
That is
dated
also required, yes.
5/5/2025 produced by Mr. Gogoi before this court on previous date. This court was placed to direct the contender number 1 and 2 remain present in the court today, and pursuant to the order of this court, representative of respondent number 1 and respondent number 2 remain present in the court. After deliberation, during the course of deliberation, Mr. Gogoi, learned counsel for the respondent number 1, submits that the process for payment of the first installment has already been initiated, and within a period of 10 days from today, the amount will be credited in the account of the petitioners. And a price call is the matter after 10 days. And further, Mr. Gogoi submits that the entire amount will be paid within 4 installments, and during the course of during this year.
Malad may also indicated that finance will cooperate regarding that part. My lord may indicate that
No,
part. It will be easier for all the sides.
no.
Even finance can also, lordship, it will be, if lordship has indicated that part, that finance is also lordship, no problem. Yep, can. Otherwise, lordship may indicate finance will cooperate as and when there is required. Yeah, assistance is required.
Mr. Goswami, the matter is between you and the court, not with the finance department.
Lordship.
He is not a party.
They are impleaded for assistance of the court. So lordship may indicate that part, otherwise everybody will be lordship. Otherwise, finance also lordship. Solia ki baat?
Further, it is provided that I have already dictated the amount will be paid in installment.
4 installments.
For installment.
That part is there. We have no general. Lordship may just indicate lordship, finance will lordship. As
In
and-
case, my lord, the file is endorsed to finance
Then-
department, they will cooperate in the matter.
That part lordship.
Okay.
That part.
Further, it is provided that the finance department will make available the fund as and when required.
Lordship.
Place the matter on.
Lordship, after 10 days, my lord may posted it, after 10 days. Lordship.
Let it be 26, my lord, is a Monday.
Okay.
26.
Lordship.
Deep lord.
Personal appearance of the respondent number 1 and 2.
My lord may respondent number 1 and 2 are no longer displayed. So lordship may indicate personal appearance of registry as well as the joint secretary.
Okay, representative.
Yeah, lordship.
Deep lord.
Pattern matter item number 2.
May I please, lordship,
Hmm.
kindly allow 10 days to file the affidavit, lordship.
Affidavit in reply.
Reply, yes, lordship.
Miss, your good name?
Egoyari, lordship,
It's so learned counsel appearing on behalf of
on behalf of petitioner.
petitioner. Press for granting her 10 days time
Yes.
to file affidavit in reply. There is accordingly allowed. Rest shall leave the matter after 10 days. Mr. Does for respondent number,
I'll be paying for 1 and 2.
then Mr.
I'll be paying for 1 and 2, madam.
1 and 2. Then Mr. Your good name, please. Then an operator for respondent number 3 and 4.
3 and 4.
Yeah.
College of.
Item 4, pattern matter.
Yes, sir, Mr. Yeah, you have any instruction?
My lord, matter may be fixed after 2 days, my lord. In the meantime, otherwise, my lord, they are not willing to release immediately because they are my.
No, bills are pending at the treasury now.
Treasury are delaying my.
So, Mr. Sharma, are you sure that on 13th
Lordship,
of
Lordship, according to us, Lordship, it has been sent on 13, it's
13.
yesterday, Lordship. So Lordship, post after 10 days, by the time perhaps he will get it. Because now it is in treasury. Treasury. My lord,
If the bill details have been sent, I can
I
get my instructions if the bills have already been sent to the treasury officer.
will share the soft copy with him. He will know about that.
heard Mr. Atia, learned counsel for the petitioner, and Mr. P. No, Mr. P. P. N. Sharma, learned standing counsel for the respondent in elementary education department. Mr. Sharma, learned standing counsel for the
Elementary.
elementary education department as per its letter of the director of elementary education dated 13/5/2025.
No.
Wherein the and submits that the amount of arrear amount has already been sanctioned and bills are submitted in the treasury. And within a period of 1 week, the amount will be credited in the account of the bills. And Mr. Sharma therefore says that the matter may be listed after 10 days. Here is according to the law, this is a list the matter after 10 days. And Mr. Soliha learned standing counsel for the finance department, who is present in the court in connection with other matters, is requested to obtain up to date instruction. And the base is for on. Okay.
On 28. Item 5.
My lord, the matter may be adjourned for the time being. Some documents are coming from university.
That's all right, my lord. Let me start. In the meantime, his paper will come. He will reply.
It will be difficult, at least.
What difficult? I will argue. You note it down. Then when the paper will come, you will show the court.
My lord, the matter may be taken up at 2. My lord.
That day, my lord, I considered because he has some difficulty. Every day, such difficulty.
No, my lord, I am not praying for adjournment the matter.
Adjournment means
Only for the time being, my lord.
Why not now? Your paper will come, you will show.
My lord, that ordinance of 1997, my lord,
Yeah.
that would be required, my lord. It's coming from the university and some other relevant documents.
After the argument also, you can show the court. If court is satisfied, court will act on that.
Well, let it be at 2 o'clock. Let it be at 2.
Most obliged.
Otherwise, my lord, may I pray, let it
We
be.
will hear you
No.
at 2 p.m.
Let it be tomorrow in the first half, not in the second half.
You have difficulty at 2 p.m.
Yes. In the first half,
Tomorrow.
Can it be, my lord, day after tomorrow, my lord, in the first half? As a
See,
first item, right?
You discuss the matter yourself, between yourself.
My lord.
I have no problem.
every time, my lord, he wants to.
No, my
run
lord,
away.
since my lord, tomorrow, my lord, some items, part hard items before your lordship, my lord. So, my lord, as a, my lord,
It is long pending. case.
At 2 p.m. then. Today at 2 p.m. At 2 p.m.
Number 6.
Lordship, herein the petitioner got herself enrolled in the BLLB course under the Guwahati University on 22/9/2008, Lordship. That Lordship will find at page 12.
Away. Volume.
Page 12, Lordship, I kindly see.
Yes.
The date Lordship will find at 22/9/2008, Lordship. Now, what had happened, Lordship? During that course, Lordship, pursuing that course, Lordship, she could not clear 2 papers, Lordship. One is paper 8.2 and the other is paper 10.1, Lordship. Now, what had happened? She preferred application before the authorities so that she may be allowed to sit for that examination. And that Lordship will find at page 24. They allowed it, Lordship. This is the application for the 10 semester 10.1 paper, Lordship. This was the application. And at page 25, for that subject of 8.2, that is semester 8, that is of semester 8, page 25, Lordship.
Page number?
25. Now, after preferring that application, Lordship, she had given the fees, Lordship, for those two papers. That Lordship will find at page 26 and 27, Lordship. That was accepted, and subsequently, Lordship, at page 28, the program, when the examination was scheduled, was published. The paper 10.1 was to be taken up on the examination was to be held on 5/7/2017, Lordship. I'm sorry, Lordship, this is 8.2, Lordship. The subject of 8.2, that is of semester 8. The second one, Lordship, 5/7/2017, Lordship. That was the scheduled date, Lordship. And for the 10.1 subject, Lordship, the date was scheduled as 29/6/2017, Lordship. That is at page 29. First one, Lordship. The first one, 29/6/2017, was the date for the subject 10.1, Lordship. Now, after publication of this program, Lordship, she went to the register to get her admit card, and therein she came to know that she won't be allowed to sit in the examination and admit card won't be issued. Lordship, the reason was that she exceeded that period of 8 years while pursuing this course, Lordship. And she preferred an application that is at page 30 immediately, but the authorities did not consider it, Lordship. And I have annexed one judgment, Lordship, wherein a similarly situated incumbent who was pursuing that same course from the same university, but from a different college, that is of JB College, Lordship, from the same year, Lordship, who got registered in the same year, Lordship. And in her case, Lordship, she was allowed by this honorable court to sit in that examination. So in terms of that, I am praying that at least one chance may be given to her to pursue that course, and so that she may complete it, Lordship. Otherwise, the whole 5 years course which she had otherwise completed, Lordship, all the subjects she had cleared, Lordship. Because of these two subjects, she could not clear, Lordship. Now, in this judgment, Lordship will see page 33 is relevant, Lordship.
Yes.
Page 33, I am reading from the beginning. After hearing learned counsels for the parties, what transpires is that Regulation 14C provides that a candidate has to clear his or her LLB honors degree within 9 years from the date of his or her first due LLB examination. However, as per the proviso, a candidate cannot appear in any part of LLB examination for more than 3 chances, with the clarification that not appearing would amount to forfeiture of chance. Applying the above regulation to the facts of the present case, it is seen that petitioner's first semester examination of the BA LLB course was held in January 2009. She has to clear the her LLB honors degree within 9 years of January 2009, which would be up to January 2018. Though time is in favor of the petitioner, the proviso works against the petitioner, since as per the proviso, the petitioner has to clear any part of the LLB course in not more than 3 chances. In the present case, the petitioner appeared in 3 chances to clear the 2 papers of the 7th semester, but failed on all the 3 occasions. This is in addition to failure to appear in the interregnum
because of her marriage and related issues. Faced with such a situation, court is of the view that two situations visualized under Regulation 14C which have to be reconciled, and the view that emerges out of such reconciliation appears to be in favor of the candidate. Moreover, having regard to the facts and circumstances of the case, it may not be wrong to accept a view which is more favorable to the candidate. On due consideration, court is of the view that it would meet the ends of justice if the petitioner is allowed to appear in the two papers, namely, number one, Women and Law and Law Relating to Child, and number two, Taxation Laws 1 of the 7th semester of the five-year BA LLB honors course as and when examination is held next. The writ petition is allowed, but without any cost as order as to cost. So that was allowed, Lordship. I am also praying for a similar relief, Lordship.
Yes, Mr. Pukan.
No, I take your lordship straight to paragraph 3, my lord, of the writ petition.
Paragraph?
Paragraph 3, page 5. Mary. That the petitioner begs to state that the Guwahati University has issued a notification number so and so dated 18/4/2012, whereby it has been categorically mentioned in column as follow. D, under quotation. The candidates be allowed to clear as many number of back papers within 8 years in respect of 5 years law course and within 5 years in respect of 3 years law course. This amendment will come into force with immediate effect. That has been annexed as Annexer 2, my lord, page 13. Page 13, Annexer 2. Clause D. Page 13, clause D.
Page number 30,
Clause D, my lord.
39,
13, 1-3.
1-3. Page number 8.
Page 13, Annexer 2, clause D.
Of the writ petition,
Of the writ.
page number 13.
13. 1-3, 13.
Yes.
Clause D, my lord, D for Delhi. The candidates be allowed to clear as many numbers of back papers within 8 years in respect of 5-year law courses. Here, my lord, the candidate is of 5 years law course. So she has to clear as many number of back papers within 8 years. Now, my lord, if we come to our affidavit in opposition. Affidavit in opposition of the university, page 2, paragraph 5. Mary. In response to the statement made in paragraph 4 of the writ petition, defendant begs to state that by notification dated so and so, Annexer 2 to the writ petition, the clause B provides that the candidate shall be allowed to clear as many as numbers of back papers. It should be clause D. Within 8 years in respect of 5 years law courses and within 5 years in respect of 3 years law course. The petitioner was a 5-year law student for the session 2008-9, and first semester examination was due in 2009, and counting from 2009, 8 years completed in 2016. And as such, she was not entitled to appear in examination for the year 2017, which is beyond the prescribed rules and notification in respect of 5-year LLB course of the respondent university. So, my lord, counting from 2008, my lord, that 8 years duration expired in 2016, but she attempted for 2017 chance. And regarding that form fill-up episode, my lord, next page, paragraph 7 and 8. internal page 3 affidavit number paragraph 7 meter. That in response to the statement made in paragraph 6 of the writ petition, the deponent begs to state that though her 10th semester was due in June 2016, but she has filled the application form for examination to be held in June 2017. But as the petitioner was not entitled for appearing in examination in 2016, she filled the form for examination of 2017 on 5/6/17, and that too without the certificate of the concerned principal, which is mandatorily necessary. In absence of the certificate from the principal, it is not possible on the part of the respondent university to allow petitioner to appear in 10th semester examination in 2017, which is beyond the permissible limit of the rules and the notification. Next para 8. That in response to the statement made in paragraph 7 of the writ petition, the deponent begs to state that petitioner without the permission of the respondent number 4, Dispute Law College, and certificate from the respondent number 4, filled up the form and paid the examination form without the knowledge and consent of the respondent number 4. And as such, the said application cannot be accepted by the respondent university for appearing in examination in 2017. So, my lord, in that factual backdrop, my lord, the writ petitioner is not entitled to appear in the 2017 examination without any certificate from the principal concerned, respondent number 4. And since, my lord, from 2017, now 2025, my lord, those period, my lord, time, my lord, around 9 years, my lord, more than 9 years. Now, there's no question raised, only an academic issue. No application has been filed for, my lord, early hearing of the matter. Since 2017, the matter is pending, my lord.
Whether the petitioner is genuinely interested to pursue the matter.
Yes, Lordship. I have been
So
told.
why the matter was not listed till since the year 2017?
I cannot say that, Lordship, but then the concerned advocate who was conducting this case, Lordship, she probably had gone to the other side and joined as a government advocate. Probably that's the reason. Otherwise, Lordship, it is an admitted fact that the incumbent in whose favor this honorable court passed that judgment, and this incumbent is of the same university and pursued the same course and the registration is of the same year, Lordship. And they cannot apply the rules differently in respect of two incumbents who were of the same year, Lordship. And this fact that she ought to have completed that course within 8 years was considered by this honorable court then also, Lordship. There was a submission made on the part of the petitioner in that case that Lordship will find at page 32, Lordship. From the bottom, the third paragraph, Lordship. Learned counsel for the petitioner has placed reliance on a notification of the Guwahati University dated 18/4/2012, which provides that a candidate may be allowed to clear the back papers within 8 years in respect of 5 years law course. On the other hand, Mr. Sharma, Learned Standing Counsel has placed before the court the Guwahati University regulation for 5 years LLB honors course. As per regulation 14C, a candidate shall be required to clear her LLB honors degree within 9 years from the date of her first due examination in LLB honors first semester, provided that a candidate shall not be allowed to appear in more than 3 chances in any part of the LLB examination. It is clarified that a candidate not appearing in any examination would lose that particular chance allowed to him. Her submissions may have been considered and subsequently, Lordship, the page 33. I had just read earlier, Lordship. So she was allowed on this context, Lordship. law cannot be applied differently, Lordship. And I pray that in her case also, one chance at least may be given, Lordship.
Yes, what is your
My
subject?
lord, kindly see the judgment referred by my learned friend. Dated 27/10/2016. It's a 2016 matter, appearing for 2016 examination. And it's a, this writ petition has been filed for 2017 examination. The candidate of that judgment, my lord, page 32 of 2008 student, my lord, for 2016 examination. And the present petitioner is of same year, 2008, applying for 2017 examination.
But
And
she has
the-
approached the court within the time.
But my lord, it is 1 year after that judgment, my lord. That judgment was for similarly situated 2008 candidate, my lord.
No, merely because the year is different, different view cannot be taken on that count.
And my lord, the petitioner will have to establish her right, my lord, under the law. My lord, if some candidate is, my lord, allowed to appear, my lord, she cannot take, my lord, advantage of that situation.
Why?
My lord, since, my lord, that the customary verdict, that judgment is also clear, my lord.
Which one?
May I please, my lord?
The fact that she belonged to the same semester, Lordship, Lordship will find that at page 32, the third paragraph, Lordship.
Page?
Page 32, third paragraph, Lordship. Case of the petitioner is that she enrolled herself in the 5-year BA LLB honors course in the JB Law College under Guwahati University on 23/6/2008. Petitioner appeared in the first semester of the said course in January 2009. Herein, in my case, Lordship, my enrollment date is of 22/9/2008, Lordship. That is at page 12. And the fact that I appeared in the first semester in January 2009 is there at in the affidavit of the respondent, paragraph 5. Page number 2 of that affidavit, Lordship, paragraph 5, the second proviso.
Affidavit of the university.
Yes, Lordship. Paragraph 5, second proviso, Lordship. The petitioner was a, have your Lordship? The petitioner was a 5-year law student for the session 2008-2009 and first semester examination was due in 2009. So in 2009 only, first semester, January 2009 only, Lordship, the first semester was due, Lordship. So it's the same session, Lordship.
Yes, Mr. Pukon, where is the decision?
Lord, I will place the decision little bit later, my lord. Yeah. The customary verdict, my lord, I will place the judgment little bit later, my lord. My lord, that judgment, my lord.
Okay, you place it during the course of the day. We'll pass the order.
Lordship. No, bless Lord.
Item number 7.
May I please, Lordship? Well, this matter is relating to selection and appointment of Lordship assistant professor. Well, we have challenged the advertisement in this case, whereby Lordship the post has been earmarked for reserve category under STP. My lord, the policy in question, Lordship, was provincialized in the under the Act of 2011 with effect from 1/1/2013. Lordship, altogether 15 posts were provincialized. And at the time of provincialization, Lordship, no policy of reservation was followed. My lord, only on the basis of the existing staff, their service were provincialized. Now, Lordship, out of this 15 posts, one post, Lordship, although it was provincialized for the that is the post of English assistant professor of English, but that person that provincialization could not be materialized because prior to that he left the college. Lordship, if you Lordship kindly come to page provincialization order, Lordship, page 13.
Page number
13, 13.
1. Yes.
Here your Lordship will find up to serial number 13. These are the posts for assistant professor. And another 2 posts, Lordship, place that is 15 and 18, that these 2 posts subsequently provincialized. Now out of this, Lordship, 13, page number 13, your Lordship will find that serial number 1, 2, and 3. These 3 posts, Lordship, they were, Lordship, STP candidate. And another, Lordship, that is serial number 11. This is Rustom Brahmo. This is also for STP, assistant professor. But he did not, Lordship, he was not in service at that time because he left the college. And this post was lying vacant. And against that vacancy, Lordship, an advertisement has been issued. That is, your Lordship will find page, Lordship, 19 is the advertisement. In the middle portion, Lordship, application in the format prescribed by the DAC Assam, height number so and so along with biodata. All testimonial from SLC owners are invited for filling the sanctioned post of assistant professor in the subject English reserved for STP. So this post is advertised post is reserved for STP, but our claim is that, Lordship, it should be general category. As per roster point, Lordship, only two posts will come out of 15. Serial number, that is serial number as per roster point, that is, your Lordship will find page 20. This is office memorandum. For STP post, your Lordship will find serial number 5. So this is 10% reserve quota, Lordship, STP. Serial number 5 is reserved for STP. This is 1. And serial number 15, reserved for STP. This is post number, Lordship, 2. In this way, up to, Lordship, 100 roster point is to be followed. But it was the duty of the college authority, Lordship, to prepare the roster point and to make adjustment of the existing staff patterns, and thereafter they could have issued the advertisement. But without doing that, they issued the advertisement, Lordship. In the affidavit, Lordship, they have categorically come with the stand taken by the repetitioner. That is, your Lordship may kindly come to page running page 44. This is the affidavit filed by the director. Lordship got it. Part 1, man in position. In the table, your Lordship will see this serial number 9, Manoj Kumar Brahmo. Lordship, in the provincialization order, your Lordship will see page 13. This is number 1, Manoj Kumar Brahmo. And second one, Jomuna Busmutari, serial number 12. This is STP. And another one is 13, Manik Nazari. This is also STP. And next page, your Lordship will find page 45. They have prepared the roster point. Serial number 5, your Lordship will see serial number 5 STP. But this post is occupied by unreserved candidate in the right column. And serial number 9, unreserved, but this post is occupied by STP in the right column. 12 and 13 similarly, Lordship, these posts are occupied by STP. So out of this 15, your Lordship will find that 3 posts has already been occupied by the STP candidate. That is Lordship Manoj Kumar Brahmo, Manik Nazari, and Jamuna Basmutari. So this post, Lordship, cannot be filled up through reserve category, reserve candidate. Already 3 persons are occupying the post of STP. So it should be undeserved. But this Honorable Court, Lordship, while issuing the notice, has stayed the operational Lordship of the advertisement, Lordship. And now, as per their stand also, these 3 persons are also occupying the post of. Only because they have prepared the roster one, that is 15, your Lordship will find page 45, STP, vacant Department of English. So only because of this, they have issued the advertisement, earmarking the post for STP. Since the 3 persons are already in position in the occupying the post of STP, so STP, this post should be reserved, should not be reserved for STP. This is our case, Lordship.
Yes, Mr. Sodari.
Lordship, here the roster register has been prepared by the college authority. And my friend is appearing, Lordship, he will have to explain how the formula was put in place, Lordship.
Yes, Mr. Mandal.
My lord,
You have for respondent number 5.
five, Lord.
5.
The respondent number 5 is relying the affidavit filed by the respondent number 4. Their lordship.
So
will
you,
find-
you have not filed separate affidavit.
Separate affidavit was not filed.
Okay.
Page 7 of the affidavit in opposition filed by the respondent number 4, lordship. Page 7.
Yes.
Yes. This is the permission for advertisement, Their lordship will find Gram College, so and so category STP. Lordship got. This is the permanent. Now, lordship kindly see page 10. Proceed everything page 10 Part 2 roster row up to 100 point. Page 10 Lordship, page 10 Their lordship will find serial number 5 STP. Then my lord, serial number 15 STP. Others are my lord, different category, my lord. And my lord, this is the my lord, roster point 100% maintained by the my lord, college authority, which has been approved by the my lord, departmental authority also. Now this my lord, roster row up to 100 point has not been challenged anywhere. So it is holding the field. This my lord, roster point maintained by the my lord, department has not been challenged by anybody before any forum. So it is holding the field. Unless it is my lord, interfered by any competent authority, my lord, the petitioner has no my lord, claim. It has to be interfered by any forum. And my lord, no appeal also filed against this my lord, 100 point roster maintained by the departmental authority. At best, my lord, if anybody is aggrieved, my lord, they can file appeal before the competent authority challenging this my lord, roster point maintained by the department. Now here is only two, lordship will find serial number 5 and serial number 10. Now prior to that, my lord, at the bencher stage, my lord, those posts are filled up by the existing people. And if this is, my lord, not considered as a my lord, valid document, then entire my lord, settled thing would be my lord, unsettled. Because somebody is holding the post of STP in a unreserved category. If it is not my lord, maintained, then his post would be disturbed. By that way, my lord, the entire settled thing would be unsettled. So this is the my lord, 100 point roster maintained. My lord, if they are agreed, my lord, they can appeal before the my lord, competent authority. There is a my lord, appellate authority. My lord, Secretary Education Department. They can approach me if they are not satisfied with this roster system. That must be.
Yes, Mr. Khan.
But in fact, that is my case because I am saying that they should follow the roster plan. So roster, as per roster plan, serial number 5 and 15 will come. So 2 posts will come out of this 15 post. And 3% has already been occupied. They should be adjusted, lordship, in the existing pattern. So 3% are holding the post of reserve category. So these 3% should be adjusted in this roster plan.
So if another person come lordship, it will again add to the register points, or it will be so lordship four candidate. That cannot be. Because these three persons, they could have a place in 5 and 15 point. They could have adjusted. They did not do. Under what basis they have come that 15 serial number is vacant? In fact, I am relying that this roster one is to be followed, and their existing pattern should be arranged accordingly. These are the persons of reserve category.
So, Mr. Mandal, going by this annexer 3, that page number 13.
Page 10.
13. Annexer 3.
Page 13, my lord.
Yes. So can it be said that you have followed the roster point, 100 point roster point?
Now, these are the, my lord, Benser College was provincialized. Now, while provincialize the service of the, my lord, existing staffs, my lord, my lord, the policy decision of the government was to, my lord, provincialize the existing staffs. That is the, my lord, main motto, and accordingly it was provincialized, my lord. Since it is a Benser school college, it was not a direct recruitment. Had there been direct recruitment, my lord, they could have, my lord, maintained the 100 point roster point.
So at the time of preparation of this order, this roster point was not followed.
My lord, partial.
Not followed.
Partial.
But
Because
subsequently you are supposed to follow it.
yes, supposed to follow it. Now, if it is, my lord, blood flow in the, my lord, true sense, my lord, then the, my lord, as I have, my lord, already submitted, my lord, the settled thing would be, my lord, unsettled, because those have already been provincialized. Now, if they are, my lord, disturbed, where they will go, my lord? That question is also, my lord.
What is the question
Looked
of
in.
disturbing here, lordship? Nobody is saying that they will be disturbed. They should be placed in appropriate
This
place.
is regarding filling up of a new vacancy.
Yes,
So those persons are already there.
already there.
They will not be disturbed.
Yes. Now, as per roster system, the, my lord, 15 serial is the, my lord, STP. Now, if it is, my lord, general, my lord, if it is made, my lord, general, my lord, then the somebody was holding the post would be disturbed, because in the next time the roster point 100 point system would be disturbed. Now, person who is holding the post of unreserved category as occupied by STP, he cannot be thrown out. And STP, STC, not STAs, they can hold the post of unreserved also under the 100 point roster system. So somebody, my friend has referred, serial number 9, occupied by STP. Now, left hand side lordship will find unreserved. He cannot be thrown out. Now, if the present post is taken as a considered as general, then what would be his position, my lord? He is already holding the STP. Thereby, the 100 point roster system would be disturbed.
Mr. Khan,
My lord.
as per this annexer 600 point roster, serial number 15.
Yes.
This post is reserved for STP.
Yes. But if this is allowed, what will happen, lordship, in respect of 9, 12, and 13?
because these posts are already occupied by the STP.
No, he has already stated that at that point of time, the college was venture college.
Yes, that policy was not followed at that time. But now they have to arrange, they have to make adjustment, and they have to place the person who are occupy person in accordance to lordship in accordance with their category of reservation. Whether if reserve category candidate should be placed in reserve category. Because STP candidate should be placed in serial number 5 and 15, but they did not do. They did not do. These 3 persons should be at least 2 persons should be placed in serial number 15 and 5 and 15. They did not do. And in fact, they have been placed at serial number 9, 12, and 13. Suppose post of 9, 12, and 13 is vacant. Whether this post will be filled up by the STP candidate, because this post was is occupied by the STP candidate. In fact, this serial number 9 is the post for unreserved, 12 unreserved, and 13 is OBC or MOBC. But these 3 posts are occupied by a unreserved candidate, a reserved candidate. So again, it will be unsettled. So base lordship, it should be these 3 persons should at least lordship 2 persons should be placed at serial number 5 and 15. Because this roster point they have to prepare in accordance with the roster point. They did not place.
Yes, Mr. Sotore, anything?
Lordship, first of all, Lordship has seen the roster prepared by the College of at page 45. Lordship, the school was the college was at the venture stage, provincialized, and as per the government OM, Lordship, it was a voluminous one, Lordship. I've taken out the relevant extract. It states that in the first preparation of the roster, first of all, as per the roster system, Lordship, the post will have to be earmarked for the category, various categories. And thereafter, Lordship, the person who were appointed at the beginning, they will be placed at the top, irrespective of the post of category for reservation. Lordship, that heading initial preparation of roster register. Lordship, may kindly peruse that paragraph. It states that at the point, it's from the handbook of reservation of post and maintenance of roster by government of Assam. Lordship, at the point of initial operation of the roster, it will be necessary to ascertain that each roster point have been earmarked for each category, namely SC, STP, STH, OBC or MOBC, EWS, and general in the roster. In order to prepare roster register initially, name of all the candidates holding the post as on the date of starting the reservation register may be entered in the register, starting with the earliest appointee who was in the cadre on the date of start of register. Lordship, that's a formation of the new cadre after provincialization. If an appointee in the cadre belongs to SC category SC, may be retained in column 5 in the register against his name, provided he was appointed by reservation. Lordship will find in the page 45. Lordship, at the last column, the remarks are given. Who the posts are being occupied by whom? Lordship, if the candidate was appointed on his own merit, unreserved will be retained in column 6. If the next appointee is a general candidate, general may be retained in column 5 in the register against his name, and unreserved in column 6, and so on till all the appointments are adjusted in the respective roster. After making entries as indicated above, details about the number of SC, ST, and OBC appointed by reservation, backlog reserve, vacancy, if any, may be indicated in remarks column. The excess reservation of particular category in the cadre would be adjusted to future appointment, and existing appointment would not be disturbed. Lordship, after the 15 posts were provincialized and the last person has left the job without joining since he has entered into another service. Lordship, that 15 number post is for STP. So the college authority, when they has to fill up, because it will be lying vacant, and that post accordingly they have advertised in connection with STP. Because Lordship, after provincialization, only a cadre was formed. So obviously, those persons who were provincial, they have to be placed in those categories. And as per the OM, Lordship, it will start from the date of early appointees. My submission will be only that, Lordship.
Where is that OM?
No, Lordship, I have just given that handbook relevant part, Lordship.
No, you were referring to one OM. Where is that OM?
Lordship, this it is in the handbook itself, Lordship, but it was quite a voluminous of about 400 to 500 pages. Lordship, I have taken out the only relevant extract. If Lordship requires, then I'll try to get it.
No, please show me the provision that at the time of provincialization, this roster system is not followed.
Lordship, because at the time of provincialization, the names are forwarded as per their seniority. And Lordship, while giving provincialization, the authorities give as a whole if they satisfy other conditions also. Thereafter only, Lordship, the roster register has to be prepared.
Where is that proposition?
Maybe I can take up these books, page 647.
Yes.
Lordship, section 4, page 653. The services of the employees of all eligible venture educational institution under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years. All those criteria are given. The number, subsection 2, the number of employees in both teaching and gathered in each of the venture education institution services of whom are provincial or to be provincialized under this act shall not exceed as specified in the schedule appended to this act, provided that when the number of such employees serving in such venture education institution exceeds the number as specified in the schedule, the provincialization of the service of the employee shall be on the basis of seniority in the respective category in the concerned educational institution. The state government shall not have any liability whatsoever in regard to such excess employee, provided further that the state government shall have no liability whatsoever in respect of any past liability of the venture educational institution whose employees have been provincialized under this act. Thus, services of a teaching or non-teaching employee in a venture educational institution up to higher secondary level shall be considered for provincialization only if they have the requisite academic and professional qualification prescribed by the relevant rules at the time of their initial appointment. In case of employees of a degree college, they must have equate such requisite educational as well as professional qualification as may be determined by the University Grant Commission from time to time. Provided that if an employee is required to acquire any prescribed academic or professional qualification, services of such employee may be considered for provincialization if otherwise eligible, but in such cases, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years from the date of coming into force of this act, and during this intervening period, he may continue to work under the existing terms and conditions under which he was working until his services are provincialized. In case of his failure to acquire the required academic or professional qualification within the stipulated time. Lordship, in subsection 2, the proviso itself provide that they will be placed on the basis of seniority in the respective category in the concerned educational institution.
Proviso to proviso.
Subsection 2. 4 subsection 2, Lordship. Provided that where the number of such employees serving in such venture education institution exceeds the number as specified in the schedule, the provincialization of the services of the employees shall be on the basis of seniority in the respective category in the concerned educational institution. Dear Lordship, the college was provincialized on 28th January 2014 under the 2011 Act.
Yes, Mr. Khan, anything to submit?
Yeah, well, the provision what my friend is relying, that is in respect of seniority. But there is no any point for lordship here for roster point. Roster point is something different. That is not based on seniority. That based on the category of employee. So this is
No. Here it is mentioned irrespective of the category.
category. That means suppose lordship in the Department of Education, Department of Political Science, Department of other subject. So in that category, their seniority would be determined on that basis. But this is not relating to roster point. So roster point is something different. That is not based on lordship seniority of the employee.
Also, forwarding the name, it has to be on the basis of the seniority. After formation of the cadre, as per the government OM, the initial appointees will be placed at the beginning, Lordship, irrespective of the post marked for the various reservation category. That's the Lordship, the handbook states.
That OM is Where is that where?
No, Lordship, I have given the relevant extract of the handbook, Lordship. Initial preparation of the roster register.
My lord, in that event also, the 15 post cannot be, lordship, here, the vacant, because if your lordship kindly come to page 13, here lordship up to 13 serial number, their services provincialized on 20 January 2014. And others two lordship, page 15 and 18, their services were provincialized later on. So these two person will come to serial number 14 and 15.
Lordship, I will try to get this OM under the heading of the initial preparation of the roster. Lordship, Lordship may allow me one day time, I'll try to get it, because it's a handbook is the compilation. Lordship, there may be the separately the OM.
Okay, then you produce it on Friday.
Yes, Lordship.
Mr. Temkan, learned for the petition. And Mr. Mandal for respondent number 4. And Mr. Soduri for respondent number 150.
4.
4 is Mr. Mandal. Mandal is 4 or 5? 5. Mr. Mandal is 5. Mr. Soduri is 4. 4. And for other respondents?
Lordship, I'll be appearing only for 3 and 4.
3 and 4. 1 and 2? Mr.
1 and 2,
Bhuya? Mr. Bhuya, you are appearing for 1 and 2? Okay. Heard in part or is the matter day after tomorrow?
Ablash.
Okay.
May I please, Your Lordship? Your Lordship, may kindly peruse the last order, Your Lordship. The claim of the petitioner, Your Lordship, made in this petition, Your Lordship, they submitted that is under active consideration of the government, Your Lordship. In that view of the matter, Your Lordship, my prayer will be, Your Lordship, let this matter be disposed of, directing the authorities to take a final decision on the matter, Your Lordship, within a specified period of time. Either way, Your Lordship, which way it goes, Your Lordship. They have not, Your Lordship, this has been, Your Lordship, for long, Your Lordship, this is the instruction they have received, Your Lordship. Rather than keeping the matter pending, Your Lordship, here.
Regarding prayer made by my learned friend, consideration of the case of the petitioner by the department, I have no objection to that department. But as I have submitted earlier, my lord, for my instruction, government is considering their case.
Since they are considering, Your Lordship, ultimately a final.
There must be definite time frame.
Yes, my lord.
It is, you cannot take the whole year that under the grave of this
yes, that I understand.
under consideration.
So let it be decided within a specific period of time, Your Lordship, 2 months, 3 months, whatever time they want, Your Lordship, in that manner. Unless, Your Lordship, that is specified, Your Lordship, this will go on, Your Lordship, that's the problem. And bureaucracy functions like that.
Yes, my lord.
Matter relates to payment of dearness allowance to, Your Lordship. The teachers who were appointed under Sarva Shiksha Abhijan Mission, Your Lordship.
Where is the impugn order?
Your Lordship, there is no, Your Lordship will see the orders, Your Lordship, by which there, Your Lordship, Annexer G, page 31, Your Lordship. And last page, Your Lordship, page 33. In fact, your lordship, they are not paid the entire amount of DA, your lordship, to which they are entitled, your lordship. That's why they are before this and are before yours. And during the pendency of this matter, your lordship, this process started, your lordship.
So as per this order, you are entitled to DA.
Lordship.
And
DA,
you-
we are entitled to lordship, but although there is a general decision of the government, policy decision, that we will be paid the pay and other allowances equivalent to the regular employees, your lordship. However, this has not been paid, your lordship. And therefore, your lordship, we raise that grievance, your lordship.
Where is that notification?
Your lordship will kindly come to my prayer, your lordship. Prayer will reveal it, your lordship.
No. Where is that
Oh, that
notification? to show
decision,
that,
your lordship? Yes. Lordship will get it. Your lordship, page 25 onwards, your lordship. First page, your lordship. In inviting reference to Deva, I am directed to state that from the beginning it was decided that the contractual LBFP teachers under the same benefit of regular teachers under the Director of Elementary Education.
So, Mr. Khatuniar, this is your notification.
Sorry, my.
This is your notification
Yes, my.
that they are entitled to.
Yes, my lord.
Then where is the bar in providing the benefit to them?
My lord. For my instruction, there is no bar, my lord.
And that's why they are considering
They
it
are
also.
considering,
your
my lord. In fact, they have sought from some report from the mission director SSA, my lord. As per my last instruction in the month of March. Today, I didn't get any instruction, my lord, from the department. So, my lord, may do one thing, my lord. Give me a week time so that I can convey the department.
But there is no problem. But you have to pay interest from the date it's due to them.
Precisely, this is not.
If you want to take that risk, I can grant you 1 week time.
That I understand, my lord, but precisely this is not the prayer made by the petitioner in the dispute, my lord.
Maybe this is a petition under 226.
That I
We
understand.
can hold the pair. And there are numerous decisions of Supreme Court to grant interest.
Yes, that I understand, my lord.
Hmm.
What I am saying, my lord, latest status as on today, since I don't have, my lord. My lord, give me 1 week time so that I can obtain the latest status regarding their consideration. And on next step, my lord, may decide the matter, my lord. If no decision has been taken by the department, in that case, my lord, may direct the department to take a decision.
That can be done today also, your lordship.
Otherwise, I have no objection regarding dispose of the petition, my lord. But since today I don't have any instruction, my lord, that is why I am paying, my lord.
Wait for 1 week.
Lords.
But Mr.
On the next day, my
Khatuniar,
lord, I will obtain the up-to-date instruction, my lord.
you obtain, but if you do not get any instruction, then definitely we will impose some interest. Heard Mr. Bortakur, learned counsel for the petitioner, and Mr. Khatuniar for respondent number. Respondent is Elementary Education Department, and Mr. Bora for respondent number 2. 4. Respondent number 4. Mr. Khatuniar submits that though on the other day, he has submitted before the court that the matter is under active consideration of the respondent authorities, yet today he could not obtain any up-to-date instruction, and accordingly he pressed for listing the matter after 1 week. There is accordingly allowed to list the matter on COVID 28 as part 30.
Lords. Deeply obliged.
Yes.
Your lordship.
Pleadings are complete in this matter, Lordship. Kindly fix it for hearing on Thursday, Tuesday, Lordship. On Tuesday, coming Tuesday.
Next Tuesday?
Yes, Lordship.
Both the parties are represented by the Ethics Council. It is submitted at the bar that pleadings are complete and the matter is ready for admission hearing. And price for listing the matter on next Tuesday. They are allowed to license the list.
Publish.
Number 10.
This is the case, my lord, where the petitioner, my lord, is not only, my lord, awaiting, my lord, the refixation with 7 pay commission, my lord, benefits, my lord, but, my lord, certain other upgradation benefits from 2012. Lord, as well as, my lord, there is a, in fact, my lord, there's a direction to recover some money because alleging some, my lord, wrong fixation at the earlier point of time. Now, my lord, he's retiring in 2027. Till date, no affidavit has been filed, my lord,
Some instruction has been received, my lord, yesterday only. Kindly 2 weeks may be given, my lord. We'll file affidavit.
Kindly?
2 weeks, my lord. Instruction received, my lord. Instruction received yesterday.
What instruction?
my lord, during the 6th pay commission, my lord, he was, my lord, granted the pay without asking any question. Now they are saying that the initial fixation was wrong. Therefore, they propose some recovery. That has been stated by this honorable court, my lord. But then his fixation is now, my lord, been kept up.
Where is that letter?
My lord, recovery letter, my lord. That has been stated by your lordship, my lord. My lord, annexure 12 is the information given a submission of overall statement, my lord.
Page number?
My lord, page number, my lord, lordship will take up 11 first, my lord. It's by the director of higher education, my lord. He's asking, my lord, that with reference to the subject cited above page 31, I am directed to request you to work out the total overdrawal of salary since the date of appointment of the incumbent concerned by in allowing incremental benefits violating the terms and conditions of appointment as per due and drawn basis and take steps for adjustment of the overdrawn amount in respect of Dipankar Das Chaudhary, assistant professor of mathematics, and submit compliance report at the earliest for further action regarding his pay fixation. Now, my lord, this is where the matter is poised at this stage, paused at this stage, my lord. Now that overdrawal, because of this overdrawal, my lord, they did not drop the fixation. I came before this honorable court. Now that fixation, my lord, overdrawal part has been stayed by this honorable court, my lord, by the last order, my lord. In fact, this come for the second time thereafter. On 26/6/2023, my lords have stated that there should not no deduction, my lord, in the interim, my lord. Now, my lord, the benefits, my lord, he is claiming, my lord, I have stated, my lord, in paragraph 14, my lord, first of all, the UGC pay scale, 7th UGC pay scale, my lord, payable from 1/4/2016, for which, my lord, the fixation is pending, my lord. Then, my lord, there has been, my lord, actually, my lord, the overdrawal was period of salary from, my lord, August 2000 to August 2021, my lord, during his initial period of joining. That they say, my lord, is to be recovered, my lord. But then my case is, my lord, that was fixed, my lord, given by them. There was no fault on my part. And, my lord, now, my lord, there is another, my lord, benefit, my lord, there is an upgradation, I'm entitled to upgradation. And from, my lord, stage 1 to stage 2 in 2012. And from stage 2 to stage 3 in 2017, my lord. My promotion also, my lord, has been held up because of this, my lord, for associate professor, which others I would have been entitled in 2020 itself, my lord. And, my lord, I'm returning in October 2027, my lord.
Yes, sir. Mr. Das, what instruction you have received?
Yes, yes.
So you have not filed any affidavit?
No, my lord. We'll file, my lord. Kindly give 2 weeks time. I will file it. Instruction parawise commentation.
So let them file affidavit.
My lord, lordship, can I kindly fix a date, since the matter of 2023 has come thereafter, my lord, only first time today, my lord, thereafter.
Heard Mr. Dotto, learned counsel for the petitioner. And Mr. S. Das, learned standing counsel for the responsive petition department. Mr. Das submits that he is received inspection and he will bring the same on record by way of an affidavit and tries for listing the matter after 2 weeks. Here is accordingly allowed, recessal is the matter after 2 weeks. You can take it back.
Yes, yes. My lord, the interim order may continue, my lord.
Interim order passed earlier itself. Okay.
My lord, Lordship, kindly fix the date, my lord.
On 4th June.
4th June. Diplomatic, Lordship.
Item number 11.
This case, my lord, in this matter is regarding provincialization of service.
It has, before my friend start, my lord, it has already been decided. The state level committee has recommended the name of the petitioner for provincialization. And now, my lord, it is pending before the government for creation of the post, my lord. Lordship will give us some time, possibly, my lord, by the time this provincialization order will be issued.
Okay.
My lord, if the process is going on, my lord, some that may be given in the meantime if my service is provincialized, my lord.
Heard Mr. M.A. Hussain, learned for the petitioner, and Mr. D. Kosik, learned counsel for the
Elementary.
in elementary education department. Mr. Kosik, learned standing counsel for the elementary education department, submits that the state level committee has already recommended the name of the petitioner. And now the matter is pending for creation of the post. And after creation of the post, the petitioner will be appointed. And to complete the entire process, Mr. Kosik tries for granting him
3 weeks time.
3 weeks time. There is accordingly allowed. Place the list of matter after 3 weeks.
Item 12.
In item 12, my lord, I have challenged a speaking order, my lord, by which my claim for provincialization has been rejected, my lord. And the ground for rejection is shown that my name is not there in the dice code, my lord. The order is at page number 120, my lord. Annexure 18, page number 120.
What?
120, 120.
121.
120, 120. From the bottom, my lord, from second paragraph, it is written the name of the petitioner Azahar Ali was not recommended as his name did not appear on dice data up to 2011 and 12. But the fact is that, my lord, my name is there in the dice data, but there is a spelling mistake in the dice data. My original name is Azahar, Azahar, but in the dice data prior in 2009, 10, and 11, it was written at AZ, my lord. I have annexed the dice data. Dice data has page number, my lord. Annexure 4, my lord, page number 67 is started, my lord. This countersigned by the district elementary education officer. My name is there, my lord, in 2009-10 Azahar Azahar Ali. In 2010-11 at 67, my lord, page number. 2010-11, it is AZA. Again in 2011, AZA, my lord. And 2012-13 also it is AZA, my lord. Later on it was corrected, my lord, and thereafter it was come up as AZA, my lord. It has come up as AZA from 2014, my lord, and it is thereafter continuing, my lord.
At page number?
It is at page number, my lord, 72 is the first page, my lord. In the second page, AZ, and thereafter it is continuing as AZ, my lord. Because of the '73, it is page number 73, and thereafter 2015, my lord, it is at page number 76, my lord. Thereafter continuing, my lord. As AJ, my lord. District Scrutiny Committee
This
has
page number 73 is of the year 2014 and
14. And thereafter, my lord, in 2015, I have also annexed, my lord. In 2015, kindly have a look at page number 78, my lord, the original one, my lord. AJAHAR, Azahar Ali. And my name was recommended by the District Scrutiny Committee, my lord.
Where is that recommendation?
Recommendation is at page number 81, my lord. Annex of 7. My name is at page number 83, my lord.
Page number?
83. As per my lord, PTR, 4 teachers are recommended because the enrollment student is higher than more than 100, my lord. My name is in the top, my lord, Azahar Ali, designation as HM, and I taught my lord Assamese and mathematics. 83, my lord, page number.
Yes.
And thereafter, my lord, when the list of provincialization has been published, which is at page number 85, my lord, my name was dropped and only 3 teachers were provincialized, my lord. At the top, my lord, page number 85, 3 teachers are provincialized, Kawadanga, Emi Madrasa. My name was dropped. Thereafter, I have approached before this honorable court, my lord, and this honorable court has passed an order with the directions to pass a speaking order for hearing the parties. And thereafter, my lord, speaking order has been passed, wherein it is stated that my service cannot be provincialized was not provincialized as because my name is not there in the
As per order of this court.
Yes, my lord.
Where is that order?
That order is at, my lord, page number 110, my lord. It is started from 110. Operative portion from 112, my lord. In the bottom, my lord, considering the facts and circumstances of the case and the nature of the prayer, this court is of the view that the petition can be disposed of in the manner as prayed for. Accordingly, the writ petition is disposed of with a direction that the Director of Elementary Education, who is the respondent number 2, should consider the case of the petitioner based on the recommendation of the District Level Scrutiny Committee, Durham, and dispose of the same with a rejoined order within a period of 2 months from the date of receipt of a copy of this order, my lord. Thereafter, the impugn order has been passed, my lord. The impugn order clearly reflected that, my lord, before passing the impugn order, a thorough analysis has not been done of the dice data, my lord. Well, my appointment, my lord, is 1997, my lord. And thereafter, my lord, at page number 66, my lord, this is the approval by the district elementary education officer. The vernacular one is at page number 66. It is clearly stated, my lord, it was issued on 2011-2006, my lord. 2011, page number 66. My name is there in Muhammad Azahar Ali. 2006, my lord. So it is clearly reflected that my name was recorded in the dice data, but in a with a wrong spelling, my lord. In place of Z, it was written as Z, my lord.
So your initial appointment letter is at page number?
My lord, no. My initial appointment letter is page number 58, my lord. 58, Annexure 1. 60 is the vernacular one, my lord. Initially, I was not appointed as a headmaster, my lord. As an assistant teacher, I was appointed. Later on, I was promoted to the headmaster post, my lord. I am taking classes of Assamese and mathematics, my lord. And my recommendation, although designation has been shown as headmaster, but subject taught is shown as Assamese and mathematics, my lords. And as per the PTR, my lord, 4 teachers were recommended, and the provision is there, my lord, in the act. 58 is the initial appointment order.
So, Mr. Kaushik, you have filed your affidavit?
My lord, we have not filed our affidavit here. Possibly, my lord, the affidavit of the SSA would be more relevant.
From 2020.
Because the dice data is, my lord, prepared and maintained by the SSA, my lord. And during the process of provincialization, we call for a record from the SSA with regard to the existence of the name of that person in the NUPA dice. And the speaking order, my lord, the district scrutiny committee though recommended the petitioner's name, my lord, the state level scrutiny committee rejected it on the ground that the petitioner's name is not there in the dice data up to 2013 and 14. Now, if what the petitioner is saying that there is a spelling mistakes in the dice data, but that verification has to be done by the SSA.
No, that verification, is it your case that without any verification, the district level committee has recommended his name?
District level, my lord, the district level committee's recommendation is not a final, my lord, under the
No,
statute.
that's all right, but
And therefore
some
there is
sort of responsibility is entrusted upon them also.
them also. And therefore, my lord, the act mandates that even the district scrutiny committee has recommended, my lord, the state level committee has to do a physical verification independently, my lord.
Whether you have carried out any
Yes, my
physical-
lord, that speaking order itself clearly indicates, my lord, the state level committee as well as the joint committee has looked into 3 categories, my lord, 3 criterias.
Hmm.
Your lordship will see page 120,
Hmm.
serial number 3, my lord.
Hmm.
As per the minutes of the meeting of the committee constituted by so-and-so, the following decisions were taken, whether the name of the school appears in the dice data maintained by NUPA 2009 or before, whether the name of the incumbent appears in dice data of 2011 and afterwards, enrollment position of the school during 2016-17 and 17-18. As per the decision of the joint committee constituted by government, the SSA Assam furnished the dice verification report to the Directorate of Elementary Education. In the said the dice verification report, the name of the petitioner Azhar Ali does not reflect in the dice data up to year to 2013-14. Accordingly, the proposal as proposed from received from the district elementary education officer was placed before the SLSC. And subsequently, before the committee constituted by the government and after verifying the records, documents including the dice data submitted by SSA, the following teachers were recommended by both the committees for provincialization of services as teacher. They fulfill the criteria laid down on Act of 2017, as well as the decision of the committee constituted by the government. These are the 3 teachers, whose names were found to be in the dice data and who fulfills the criteria. Here the petition now decision, my lord, will kindly see.
No, you come to the second point, whether the name of the incumbent appeared in dice data of 2011
And afterwards. Yes.
Why not in 2009 and 10?
No, that's the requirement under the Act, my lord, after 2011. The school needs to be there in the 2009 and 10. Because as per section 4, my lord, there has to be a continuous 7 years of service.
From which date it will be counted?
Till 2017, then 2011, my lord, 6
No,
years.
from 2009, 10 onward?
I mean, well, Lordship will kindly see. Four Roman 3, my lord, 1 page 117.
Page number?
Page
number 117.
115, my lord, in this. 115. In this.
115, yes.
4?
4 subsection 2, my lord. The teachers and tutors to be provincialized under the Act, he must have been working in it as a teacher in the concerned venture education institution as mentioned in section 311 that have been recognized by the competent authority on or before 1/1/2006,
must have minimum educational qualification, professional qualification as laid down under the different acts, rules and regulation as mentioned under section 6 and other relevant statutory provision as the case may be. Roman 3 would be relevant. Must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining on account of venture education, which must be on 31/12/2010 or prior to that date.
Then why it was in the year 2011 was taken into account?
Because the cutoff date, he has to be prior to 2010 or prior to that date. To ascertain whether he was at 6 years of continuous service on the date of 1/1/2017, this 2011 dice data is considered. 10-11 dice data. 11 means it would be 10-11 dice data.
So totally you are appearing for SSA. So you have filed your affidavit?
We have not filed the affidavit, but as per the instruction received lordship from the NUPA dice till 2012-13 lordship, the name of the person Azahar Ali with the alphabet J lordship, AJ. And now
That's
the
all right.
petitioner is,
It is his categorical contention that there is a mistake of mentioning his name.
lordship, 1 year there can be mistake, 2 years there can be mistake. From 2006-7 onwards, lordship, the same mistake cannot be repeated.
No.
Secondly, lordship, whether the Azahar or Azahar, AZ or AZ are the same person, that has to be verified by the district authorities, lordship. Because lordship, the NUPA dice has to be renewed every year. Every year they have to file an application.
No, that's all right. But it is not the business of the petitioner. It is the headmaster of the concerned school. He will.
It's the school authorities, they have to again apply for renewal.
Yes.
That's why, lordship, I am saying.
From a personal experience, I have said, my lord, in the electoral.
Lordship, that's why I'm saying that 1 year there may be mistake in the spelling of his name. 2 second years also there may be mistake. How it can be for more than 10 years, lordship? That's the issue, lordship. Whether the same person whether one person is having 2 spelling are correct or not, that has to be verified by the district authorities, lordship. For 1 or 2 years, lordship, mistake that can be accepted. For 10 years, lordship. Same mistake has been repeated. The school authorities apply for renewal of the dice. If he found out in 1 year the mistake was there, obviously on the next year, lordship, he ought to have, whoever was the signing authority giving the form, ought to have told them.
In fact, if I may point out one
so
thing.
happened that it was not brought to the notice of the petitioner.
Well, how can it be, my lord? My petitioner has said, though his initial appointment as an assistant teacher, my lord. Well, just one point. The petitioner has said that he was promoted as the headmaster. He was acting as the headmaster. He is the one who submits the dice data for inclusion of the names of the teachers. He was the headmaster.
No, he was not headmaster at the initial point of time.
No, not initial point of time, my lord. But subsequently, he became the headmaster. He was a custodian of the school. He is the custodian of the school.
My senior friend has already been stated that it is the duty of the district authority, my lord. District authority scrutinize the matter, and my name is recommended, my lord. And that apart, if we go through the dice data, my lord, it is clearly indicated the date of appointment, my lord. In all the dice data from the 2009 till date, the appointment year has been written as 1997, my lord. And my appointment is also in 1997, my lord. Even from a personal experience, I have to state, my lord, even in the electoral roll, my name is always wrongly recorded. After 5 times, my name was corrected when I repeatedly approached, my lord. This is the
somebody has to
my
approach.
lord.
They have page 14, paragraph 5 of the repetition. It is his categorical statement that since 2006 to 2000, he is being promoted as headmaster.
He repeatedly approached, but later on it was corrected, my lord. If the authority did not correct it, can it be blamed on the persons? So After proper verification by the district authority, my name was recommended, my lord. And my learned senior colleague has already been stated that it is the district authority, my
2006
lord.
to 2013, my lord, his name appears as AZA. And in that period of time, he was the headmaster, my lord. Because during that period of time, he was the headmaster. Paragraph 5 of the repetition, my lord. He assumed the charge of headmaster on 6/2/2000.
Lordship can peruse the data.
Every year,
You were referring to
paragraph number 5 of the repetition, page 14. 6/2/2000.
14.
Page 14. I would have understood, my lord, he is not the headmaster, my lord. The headmaster has wrongly submitted the name. Every year, he submits the name for inclusion of the teacher's name in the DICE data. And how, in the what form, but in whatever form it is submitted by the headmaster, the DICE data is enrolled in that same form. Until somebody comes and make a complaint or make a request for verification that my name has been wrongly been done, only then the authorities' role will come, my lord, for verification.
So you verify it again.
My lord.
If your lordship directs, there's no problem, my lord. But this fault cannot be attributed upon the authorities, my lord.
No. You have to verify whether that
person is
Azahar
same.
and Azahar whose name appeared later on is the same person or
My
not.
lord. That will be verified, my lord.
Because the speaking order is put to challenge. Your lordship will see in the speaking order there is no wrong, because the decision-making process there is no wrong. This honorable court directed us to pass a speaking order.
No.
And the
While passing the speaking order, you have not taken into account the recommendation of the district level committee.
But we have taken the recommendation. Your lordship will kindly see what is the responsibility casted upon the state level scrutiny committee, my lord, under the act.
That's all right. But
district level committee, my lord, even if I have recommended, that will not be a binding upon the state level committee to accept it.
Not binding, but whether you have verified the record.
Yes, my lord. That is what categorically it is said that the DICE data was verified and it is found that this name was not there.
No, you have not verified whether that Azahar Ali and
the Azahar the same
Ali
in one
is the
person.
same person or not.
That was not verified, my lord.
My lord, that aspect only when it is pointed out to the authorities, no, my names were incorrect in the DICE data. That was never a case of the petitioner.
No. Once the district level committee has recommended his name, the state level committee ought to have asked on what basis they have recommended his name.
No, that is why, my lord, this statute, my lord, if your lordship kindly, section 13, my lord.
Page number 122.
My lord, page 122.
6.
So it is there.
Yes.
Responsibility upon the state level committee.
And
is
when
there.
there is a difference with regard to recommendation of district and the state, my lord, it is the state's recommendation which is final, as per section
No,
1311.
that's all right. There is no doubt about it. There is no quarrel about it. But who is in the ground level?
It is the district.
So whose recommendation has to be
Well,
considered?
there are cases where district has not recommended, but the state found it people eligible, and state has recommended it.
That's
So
all right.
therefore, my lord, this exercise, my lord, done by the authorities, my lord, it was never a case of the petitioner that his name was wrongly recorded in the DICE data. It is only in the first district petition he has pointed out that his name was wrongly recorded in the DICE data. And the DICE data that is maintained from 2006 to 14, his names appear to be in a different spelling. Now, one single word can make a difference to a identity of a person also. But the petitioner was never diligent in rectifying his name Because he was the headmaster, my lord, I would have understood he would have been an assistant teacher, my lord. Headmaster may have committed a mistake. He did not know about it. Anyways, I'll leave it to your lordship. Your lordship, if directs us the district elementary education officer to make a physical verification as to whether this
Person or
same or not, that perhaps can claim.
So better you do one thing. Whether district elementary education officer is a party here.
Yes.
Yes, my lord.
Yes.
He's
That's on the
also a
number
ma-
3.
Yes.
Let him verify and submit a report before this court.
My lord.
My lord.
My lord.
My lord, indicate that in the order.
My lord. A specific indication may be given, my lord.
He's respond number 3.
Initial
Or
appointment.
Mr. M.A.I. Hussain, learned counsel for the petition. And Mr. Kaushik, learned standing counsel in elementary education department. And Mr. Sudhir for respondents in BTC. SSA. SSA. Respondent number 5 and 6.
5 and 6.
5 and 6. During the course of deliberation, Mr. Hussain, learned counsel for the petitioner, that the name of the petitioner continuously appeared since the year 2009 10 till 2012 and 13, and later on. However, the spelling in the data of the year 2009 10 till 2012 and 13. When it was corrected? 14.
14.
Appears as Azahar Ali. A-Z-A-H-A-R Azahar Ali. But his actual name is Azahar Ali. A-Z-A-H-A-R Azahar Ali, and same was corrected in the year 2014. But while passing the impugn order dated 16 July 2022, the respondent number 2, the director elementary education officer, has rejected the prayer for provincialization of the petitioner on the ground that the name of the petitioner, Azahar Ali, A-Z-A-H-A-R, does not appear in the Dias data up to the year 2013-14. But his name consistently appearing since the year 2009-10 till date, and he is the same person whose name appears as Azhar Ali in the Dias data of the year 2009-10 till date. And on the basis of verification, the district scrutiny committee has recommended his name, but the respondent number 2 has ultimately dismissed his petition, dismissed the prayer of provincialization of his service by the impugn order dated 16 July 2022 on the ground of absence of his name in the Dias data for the year 13 and 14. Mr. Sodhuri, learned standing counsel for the SSA, has produced the Dias data for the year 2000, from the year 2000, since the year 2006-7 till 22-23, and it appears that the name of the petitioner in the Dias data as Azahar Ali, A-Z-A. Azahar Ali appeared in the Dias data of the school till 2013 and 14 from the year 2006 and 7. And since 2014 and 15, his name appears as Azahar Ali. Azahar Ali. Mr. Soudhary, no, Mr. Hussain, learned counsel for the petitioner, submits that the state level scrutiny committee, without verification of the data, data of the earlier year, has dismissed the pair of the petitioner. And as such, a direction may be issued to the district elementary education officer, the respondent number 3 of Durham district, to verify the record of the petitioner's school to ascertain as to whether the present petitioner and Azahar Ali, whose name appears in the Dias data for the year from the year 2009, 10 till 2013 and 14, and 2014, 15 till 2022, 23 is the same person or not. Mr. Hosik, learned standing counsel for the respondent in elementary education department, submits that he has no objection if such direction is issued to the respondent number 3 to make a verification and to submit a report before this court. Whereas taking note of the submission of learned counsel for both parties, and also as agreed upon, it is provided that the respondent number 3, district elementary education officer Durham, shall make a verification as to whether Azahar Ali is that whose name appeared in the Dias data of the school petitioner's school since the year 2009, 10 up to 2013, 14, and 14, 15 up to 22, 23 is the same person or not. Please comment
On 13th June.
13th June.
Hello.
A copy of this order be furnished to Mr. Hosik, learned standing counsel for the respondent number 3 for doing needful.
Good one. Now, that even in the appointment order, joining report, his recognition, approval of the appointment order, everywhere it is mentioned as AZ. Not
that is the type copy, my lord. I have typed it wrongly. I have typed, because originally in Azahar, Z is the original word, my lord.
Let it be verified.
Items 13 and 14.
Babla? Babla? Everybody love one.
My lord, in item 13, department was supposed to file the affidavit on last 3 occasions. My friend said they have already got the affidavit ready, but could not.
Okay. My lord, in the last occasion, Chief directed to file our affidavit, my lord. Accordingly, we have sent for waiting, my lord, and they, after signing this affidavit, my lord, this in our chamber, my lord, but due to some misplaced, my lord, the affidavit. So I pray for take up on next week, my lord, any date, my lord. In the meantime, I will file our affidavit, my lord.
Misplace is in misplace. Betting
Betting. Yes, Mr. Decker.
Yes, my lord. Lordship, kindly have a look on this honorable court order 12/6/2024, my lord. This matter, my lord, on 3/5/2024 listing for the admission, my lord. And 12/6/2024, my lord. Some direction made by this honorable court, my lord. And in the light of the direction, my lord, in the present case, my lord, from the director, my lord, to the senior standing counsel, my lord, given all the SLC report as well as the hearing report, my lord, wherein the lordship, my learned friend, my lord, and my senior, my lord, has filed one additional affidavit in the matter and closed this matter, my lord. The stand of the government is very much clear, my lord. It is available before the records, my lord. So what further affidavit is required, keeping the matter delay in that matter, my lord? Since 2021, my lord, I am depriving from getting my appointment on provincialization. I am admittedly social science teacher, my lord. What happened, my lord? The district scrutiny committee recommended 4 teachers, 2 language, 1 mathematics science, 1 social science, and I am the social science. Thereafter, my lord, SLC selected, appointed, given appointment 2 language teacher, 1 mathematics, but depriving me. Then I approached before this court, my lord, making them party in the matter, my lord. And after hearing all the side, my lord, it is admitted that they are in language teacher, I am social science teacher. Thereafter, national court directed the director to decide on the entire matter, my lord. Actually, who is actually teaching which subject, my lord? Then, my lord, during the pendency of the matter, my lord, the petitioner, my learned friend, is representing me. His appointment was cancelled, my lord. Then he approached this honorable court, this filing of the instant writ petition. On this 12th, 2024, this honorable court directed to file the report. And report, my lord, in by February, my lord, after hearing conducted, my lord, I have been found the social science teacher, my lord, despite the findings on the part of the respondent department, my lord, I have been deprived from this all the occasion, all the one after another taking this time, but I'm not getting this appointment for the provincialization. And one more submission I have to place before this court, my lord. Suppose, my lord, if the enrollment is above 100, then there is a, here's a also case, my lord, he is also entitled for the, but 2 language teacher, 1 mathematics, this is a violation of the section 3111, my lord. As per the 2017 Act, my lord. The 2007, even this honorable court recently one case, my lord, in the, I am the one of the petitioner, my lord, it is held that the 2 language teacher cannot be. If the 3 posts are available, then 1 mathematics science, 1 social science, 1 language teacher. But here in this case, my lord, 2 language teacher, 1 mathematics. But my appointment in 2000, when I'm not getting to join, my lord, then all the occasion, my lord, one after this prayer, if your lordship fix them, after 2 months, even same prayer will come. Then this is the situation, my lord. So my humble submission, my lord, since the stand of the government is available, the matter may be disposed of today itself, my lord. What is the problem of writ petition? Why my lord friend is praying that they are going to file whether or not? Since all the materials available before this court, they have filed their government stance, my lord. It is further giving time. It's not, I think, my lord, it's not further giving them time to, my lord. Since their stand is very much clear, my lord. If the petitioners agree on this point, then this matter he may withdraw.
My lord, only thing is that what my friend is saying, I don't think I should make any submission. It is the, I filed the case against the department for cancellation of my provincialization. They are taking the stand as to why they have cancelled. I need to know that. And that only comes from the affidavit from them. It is not that I'm buying time because my cancellation is done. He's not even provincialized. My provincialization is cancelled. I'm before the court. He's yet to get provincialized. It is not that I am buying time. I want the case to be done. But at the same time, if they are asking for the time, I cannot deny it.
Let's see if it next week, my lord.
Mr. Talukdar, so when you will be able to file your affidavit? Next week, any day. Okay. Third, Mr.
Jayabedin Malak.
Jayabedin, Learned Counsel for the petitioner. In item number, you are in item number
13.
13. And Mr. Deka in
For the respondent 7, my lord.
7. And Mr. Talukdar for respondent in elementary education department, and Mr. Ogoimbo, respondent number 3. Okay. Mr. Talukdar submits that he has received the signed affidavit from the respondent authorities, but the same get misplaced in his chamber, and he prays that he may be granted 1 week time so as to enable him to file the affidavit in opposition. There is accordingly allowed, raise the matter
On 21st.
21st.
Deeply obliged, and my lord.
May I please, your lordship? Lordship, item number 14 may be heard today, your lordship. 13 is not, maybe item number 14 may be heard, your lordship, on last week. Because in this matter, your lordship, because of their dispute, your lordship, I have been deprived from my salary, your lordship.
Item number 14 is.
And they have no
connected
objection. 14 is for salary, your lordship. I am the headmaster, your lordship, and because of the litigations, your lordship, my salary has been held up, your lordship. I can satisfy your lordship, your lordship, on record that my salary will release, your lordship.
Yes, Mr. Talukdar.
I'm not parties in this matter.
No, Talukdar.
Because of no need of affidavit in this matter. On the record, your lordship, and on the order passed by this honorable court, I can satisfy you.
In this.
In item number 13, he is respondent number 8, my lord. So let him come together. No, lordship. My case is not salary. I have been applied for salary since 2021 because of their litigation. So far as my appointment, my provincialization is concerned, there is no dispute, your lordship. As because your lordship, in the earlier round of litigation, I was made a party for headmaster, your lordship. There was an interim order passed by this honorable court that till the final decision is taken by the authority concerned, the provincialization of mine and the petitioner in the instant writ petition, item number 13, kept in abeyance, your lordship. Subsequently, it has been decided, your lordship. One, Abdul, this is the petitioner in the item number 13. His appointment has been cancelled. So far as my position is concerned, your lordship, I am the headmaster. There is no dispute. But so far as impugn order in the item number 13, your lordship, it has not been elaborately reflected. So it is because of that, your lordship, my salary has been held up, your lordship. And so far as my learned friends from both sides are present, your lordship, they will not object. So far as my salary is concerned. Because dispute is between one side.
What is the order by which your salary is held up?
There is no order, your lordship, but I can say, your lordship, may kindly see annexure. Annexure, page number 28, annexure J, your lordship. Page number 28, annexure J. This writ petition, WBC number 1345/2021, was filed by Shahidul Islam. He is the respondent in item number 13, your lordship. And lordship, item page number 29, lordship may see respondent number 7, Abdul Rashid SK. I am the petitioner in item number 14, your lordship. Now, lordship may kindly see, I am the headmaster. Paragraph 5.
Where is the order for holding up your salary?
Page number 31, your lordship. Page number 31, paragraph 5. While issuing a notice of motion by order dated 1/3/2021 as an interim measure, the court had provided that the provincialization respondent number 7, that is the petitioner in the instant case, and 8 be not be given effect until further orders. Aggrieved by the said interim order, the respondent number 7 and 8 have filed an interlocutory application under Article so and so, vacating the interim. The said application was registered as so and so. The petition has constituted the paragraph number 7 altogether has been heard. Now, your lordship may kindly see page number 34, para 14.
Yes.
Considering the factual matrix that although petitioner was appointed as HSC science first teacher, but the DSC found that the petitioner to be teaching social science studies subject and the respondent number 7 and 8 were both found by the DSC to be language subject. Therefore, the interim order dated so and so passed in the writ petition could stand extended till fresh determination is made by the respondent number 2. However, it is clarified that while determining the matter, the respondent number 2 shall not be influenced by this order, thereby extending the interim order of the aforesaid. Now, your lordship, there is the authority has decided, your lordship, I have filed an additional affidavit bringing the order at page number 46. Additional affidavit, page number 46, your lordship. This is the order, your lordship. pursuant to the direction passed by this honorable court in the earlier round of litigation, Your Lordship. In compliance of the honorable High Court's order dated 27/1/2022 passed in WBC number so and so, and based on report of hearing dated so and so in respect from WBC number so and so, Shahidul Islam versus State of Assam, also as per decision of the SLSC minutes dated so and so, the provisional service order issued by the so and so, dated so and so, in respect of Abdul Rashid SK. Tutor was West so and so of Dhubri district is hereby cancelled. Abdul Rashid is the petitioner in the item number 13, Your Lordship. I am the respondent number 7 in the earlier, I am the headmaster. My service is intact, Your Lordship. My service was not cancelled because of there was an interim order, Your Lordship, in earlier round of litigation. My salary has not been released since 2021, Your Lordship.
No, that interim order was till the passing of this order.
Yes, Lordship. I have filed representation also. That was also not disposed, heard, Your Lordship. Then I came, Your Lordship. Lordship may direct to release my salary. Lordship may kindly see deed petition page number 41, main deed petition annexure M, Your Lordship. This is my duty certificate, Your Lordship. Headmaster of my base school. Last page of the deed petition, Your Lordship, page number 41. Since 6/2/2021, I have been serving in the school, Your Lordship.
Yes, Mr. Talukdar.
My lord, his prayer is to dispose of the representation. No, my lord. It was an interim prayer, Your Lordship. That was not considered. My prayer, that was an interim prayer for consideration of my. To dispose of the representation, my lord, then authority will decide, my lord. No, Lordship. Representation was my interim. So my humble prayer is just let the matter come on 21st, my lord. In the meantime, three occasions, Lordship, matter has come earlier before taking Your Lordship.
No, Mr. Talukdar. If you go through the order passed by this
My lord,
court,
that's why, my lord.
the interim order is extended till the date of passing the order by the respondent. Order that is in page number 46. You see it?
My lord.
And you also please go through the order at page number 30.
So at this stage, my lord, my humble prayer is that let the matter come on 21st. In the meantime,
No,
I will take instruction in this matter, my lord. Counsel for the litigants, from both sides are present, Lordship. Both of them present. They have no objection.
No, Mr. Talukdar.
My lord.
You please go through this order at page number 29 of the writ petition. You appraise this court after at 2 o'clock.
Item number 13 and 14 to continue.
I have gone through the my lord order, my lord.
Yeah.
And accordingly, my lord, I talk with the department. Lordship may dispose of the matter.
Dispose of the matter. Okay.
Pending matter, item number 5.
Obliged.
Meet with your lordship.
Yes.
My lord. So this petitioner, they wanted, applied for no objection certificate from the government and university. Actually, our case is that government is nothing to do in this case because our case is on the basis of National Council of Teacher Education Act 1993. So this is a central act. So any provision of the central act cannot be controlled by the
In which matter you are arguing? In the IA or in the main petition?
main.
Main. Okay.
We want to, when the main will be finished, I will automatically go.
Okay.
Your lordship can straight go to page 8, para 2.
Yes.
My lord, that the petitioner beg to state that the university is, the Guwahati University in this regard proceeded with an application sent by committee of inspectors to inspect the institution of the criteria specified by the processing of application required of NCTE. But surprisingly, in the meantime, university issued an impugn notification dated 24/5/22 after the application was made by the petitioner, stating that executive committee resolution was made on 29/3/22, bearing number so and so, that by respective institution required first to seek a no objection certificate from government in order to obtain NOC from the university. This impugned order was in violation of the guidelines stipulated in the NCTE Regulation 2014 and judgment passed by Honorable Supreme Court in State of Maharashtra versus Sant Dearness so and so, where it has held that no objection certificate from the state government is absolutely not required by the university to provide consent for affiliation and thereafter to grant recognition by NCTE to institution for starting B.Ed education, hence this petition. Then your lordship will go to page para 4, my lord. That the respondent number 1 in the instant case is the petitioner is the state of Assam, represented by Secretary to the Government of Assam Education Department, Assam Secretary Dispur, Guwahati, so and so. The as
You are reading paragraph number?
Paragraph number, minor, it is 4, page 10.
Okay.
Lordship can go to page 10.
Yes, yes.
Education which impose restrictions without having jurisdiction to do so, and whom respondent number 4 have arbitrarily relied upon to provide no objection certificate, NOC, from the state government, consent of affiliation. Respondent number 2 is the State Council of Education, Research and Training, and represented by his director having his office at so and so, so and so. Then your lordship, this is the, then your lordship will go to page 11, para 5. That the petitioner beg to state that Hamak College of Higher Education, Nagaon, is founded by Hamak Rural Development Foundation, Nagaon, in the year 2022 to decided to undertake affiliation to Guwahati University for undertaking B.Ed and BSc B.Ed and BPEd courses as per the guidelines of the National Council for Research Education. That in this regard, by the reference number so and so, dated 8/2/22, the petitioner paid rupees 4,84,000 to the university in order to obtain the no objection certificate for affiliation of its B.Ed and BSc B.Ed courses, which were duly acknowledged by the Guwahati University. Pursuant to this, the state government, State Council of Education, Research and Training, Assam, submitted a inspection report to B.Ed and BPEd and BA, B.Ed and BSc B.Ed courses for elementary education department, Government of Assam, for recommendation to the Eastern Regional Committee of the National Council for Research Education. The petitioner, para 6, the petitioner, I'll go to the annexure later on, my lord. The petitioner begged to state that the university, meanwhile, on 24/5/2020, arbitrarily took out impugn notification bearing number so and so after the date of application for affiliation as made by the petitioner. The notification notified that from then onward, Guwahati University would accord permission to open a new college stream subjects after obtaining no objection certificate from the state government by respective institution. In this regard, all the concerned parties who have already applied for the same but were pending for decision were thereby required to submit a state government no objection certificate in the office of the Director College Development Council. It further stated that those colleges concerned bodies who they were interested in opening new college stream subjects were to submit a government no objection certificate along with the necessary applications, without which the matter would not be processed. According to Guwahati University, by his notification dated so and so, Executive Council, a copy of the university resolution bearing May number so and so is annexer 3. Your Lordship will consider annexer 3 at page, my lord, 31, last page. This is the notification which we have challenged, my lord. Notification dated 24/5/22. It is notified for information of all concerned that from now onward, Guwahati University was accord permission to open a new college stream subjects after obtaining the no objection certificate from the government by respective institution. Therefore, all concerned who have already applied for the same but are pending for decision are hereby requested to submit government no objection certificate in the office of the Director College Development Council. Also, the college concerned bodies who were interested to open new college stream subjects are to submit government no objection certificate along with the necessary application, without which the matter would not be processed. This is issued as per EC resolution number so and so, so and so. Now, my lord, your lordship will go to page 13, para 7, that the petitioner begged to state that he would gather some information from NCT, may invite application for recognition of the intended B8 colleges institution shortly, and therefore the petitioner is urgently in need of the NOC indicated in the notification dated 24/5/2022. However, it is made clear that the Supreme Court judgment, namely State of Maharashtra versus so and so, reporting so and so, no NOC is necessary from state government by the authority, that is university, to grant recognition, and therefore the NCT for the intending college for the purpose of.
That decision is filed by you,
My lord.
that decision of the Supreme Court?
That is.
Yeah.
Yes.
That page number, which paragraph it is stated?
Yes, yes. It is, my lord, page 14. 13 and 14, my lord.
Paragraph number?
My lord, your lordship will. I continue. I have marked the paragraph with the flags, my lord. Exactly similar, my lord, background and fact.
No, this decision is available here. Where is the observation?
Observation, I will take your lordship. First is at my lord, 5 of 34. Then, first paragraph, my lord. The High Court held that in the light of the relevant provisions of the Act, as interpreted by this court in various decisions, the appropriate authority to take decision regarding opening a new college was NCTE, and neither the state government nor the university can act contrary to the decision of the NCTE. According to the High Court, under the Act, the only authority which would make a decision regarding opening a new B.Ed college or increase in the intake capacity of the NCTE, and such decision cannot be ignored by either the state authorities or by the university. So far as the functioning of the state government was concerned, the High Court observed that it was in the nature of supply of necessary data and materials so as to enable NCT to undertake the process of coming into a appropriate decision, but the state had no power to decide that it was taken a policy decision not to grant permission to open new B.Ed colleges or a particular period for a particular period. Such a decision was not in accordance with the provisions of Act, nor in consonance with law laid down by this code. Regarding role of the university, the High Court held that it was incumbent on the university to take a appropriate decision and consequential action on the basis of decision of NCTE and the provisions of the University Act, and requires the university to implement such decision. It was therefore not open to the university to take any action overlooking the decision of the NCTE and relying on a decision of the state government. In the light of the above findings, the High Court allowed the petition filed by the institutions and dismissed the writ petition of the state government.
Then next.
Next, my lord. These are the arguments that were submission. Please forward by the. Then one paragraph I want to show you, lordship, page 10 of 34. 10 of 34. Third paragraph, my lord. 10 of 34. National Council for Teachers Training Act 1993 has been enacted by Parliament and deals with the teachers' education. It came into force with effect from July 1, 1995. The preamble of the Act is relevant and reads thus: an Act to provide for the establishment of a National Council for Teachers Education with a view to achieving planned and coordinated development of the teachers' education system throughout the country. The regulations and process of maintenance of the norms and standards in the teacher education system and for matters connected therewith. Then last paragraph, my lord, under that section, university means university defined under clause. F
that's all right.
No, my lord. Then your lordship will go to the exact, my lord, decision of the Supreme Court.
Paragraph number.
My lord.
Page number.
Page number 17 of 34.
17.
17 of 34. In St. John Teachers Training Institute, the validity of the regulations, particularly clause E and F, of the regulation 5 came to the
you come to the ratio of the case.
ratio, then all I'll come to the ratio. Then your lordship will go to page 26 of 34. Second paragraph, my lord. From the above decision, our decision in our judgment, the law the law appears to be very well settled so far as coordination and determination of the standards of institution of higher education, of research, scientific and technical institutions are concerned. This subject is exclusively covered by entry 66 of list 1 of schedule 7 to the constitution, and state has no power to encroach upon the legislative power of the parliament. It is only when the subject is covered by entry 25 of page list 3, it's concurrent list of schedule 7 to the constitution, that there is a concurrent power of the parliament as well as the state legislature, and appropriate act can be by the state legislature, and appropriate act can be the state legislature subject to limitations and restrictions under the constitution. In the instant case, admittedly, Parliament has enacted 1993 Act, which is in force. The preamble of the Act provides for establishment of National Council for Research Education, NCTE, with a view to achieving planned and coordinated development of the research education system throughout the country. The regulation and the proposal maintain of norms and standards in the teacher education system and for matters connected therewith, with a view to achieving that object. National Council for Research Education has been established at 4 places in the central government. It is thus clear that the field is fully and completely occupied by an act of parliament and covered by the entry 66 of list 1 of the schedule 7. It is therefore not open for the state legislature to encroach upon the state field. Parliament alone could have exercised the power by making appropriate law. In the circumstances, it is not open to the state government to refuse permission, relying on the state act or a policy decision. Even otherwise, it is, in our opinion, the High Court has fully justified in negating the.
Okay,
Madam.
Okay, any other point?
And then, my lord, page 27 of 34.
So here it is stated that NCT is the final authority.
Central authority, and and in our case, state government has also not legislated any act. Only a executive order by the University Executive Council has negated the power, tried to negate the power of the central act, and refuse to give the permission or recognition to the to our institution. Then, my lord, there are similar cases. I will give the paragraphs and the copy to your lordship later after conclusion of my argument. Now, my lord, that is the moot point. Then, my lord, I will take your lordship to the affidavit in opposition filed by the Guwahati University. At page 31, it starts. and page 34, your lordship will find the relevant portion. Para 4, my lord. There we have said that the Guwahati University has no power to interfere with the process. With regard to the statement made in the paragraph 1, 2, 3, 4, and 5 of the aforesaid writ petition, while putting the writ petitioner to strict proof thereof, reiterating the statement therein, this the deponent humbly begs to state aforesaid Hamak Rural Development Foundation has one institution, namely Hamak Rural College of Education, already affiliated to the Guwahati University, in the same locality with the same direction, same director for the same purpose of running B.Ed program. On 23/6/22, a communication has been received from the aforesaid writ petitioner college requesting to issue an NOC BA, B.Ed and BSc B.Ed courses number so and so, which communication has not been indicated in the entire writ petition. That is not correct, my lord. I'll show you, lord. In the meantime, a communication has received from the office of the additional director general police requesting to provide documents, information, whether the institution, namely Hamak Rural College of Education, Nagaon Dhing Road, Hamak Secondary Education College, Nagaon Dhing Road, Hamak Rural ITI of Sarsil, Nagaon Dhing Road, and Hamak Group of Institution at Nagaon Dhing Road are affiliated, requested to have some official documents in this regard. This communication has been sent in reference to the registration of Nagaon Sodor police case number so and so of the IPC. Afterwards, communication was made, has been received from the said office, the additional director general of police CID Assam, communication number so and so,
Okay.
5822.
Okay, any other point?
My lord, then my lord, your lordship will go to my relevant answer to the above things, my lord. I at page, my lord. At page, my lord, 44. Paragraph 5. Included, my lord, at annexure 4, paragraph 4, to remove the confusion that we have run so many, but there is no, they are not same and they are connected with different courses. Paragraph 4, page 44. That with regards to the paragraph 3, deponent wholly denies this assertion and begs to state that response number 4 have
Okay, Mr. Puragoy. Yes, Mr. Pukon.
Then, my lord, your lordship, I'll take your lordship to page 45 also. There I have said that these colleges are giving different type of, my lord, dealing with different.
Okay, I have seen it.
My lord.
Yes, Mr.
Then, my lord, another point that has been raised by my learned friend, that some FIR has been filed against us.
That is in the affidavit itself, so they have mentioned it.
Yes, my lord, that those cases has been interfered with by the Honorable High Court. That is, my lord, one is by order dated 5/8/24. The last page says it is further decided that, directed that until further orders, the further proceedings of ERC number so pending in the court of learned chief judicial magistrate Nagaon shall remain stayed. So this case has been stayed here. The other case, my lord, the order by 21/6/24 is also said till returnable date, it is hereby directed that the further proceeding of ERC number so and so in the
Okay.
Court of Judicial Measure Nagaon is shall remain stayed.
Okay, please
All
sit
the,
down. Please sit down. Yes, Mr. Pukan. What is the basis for issuance of this notification dated 24/5/2022?
Lord, this office memorandum in 2019. And after that, my lord, in 2022, this Executive Council resolution has been passed under Government University Act. Since it's a state university under the state government, so we'll have to abide by the policy decision, the office memorandum of the state government.
Where is the policy decision of the state government?
My lord, the writ petition, my lord.
Yes, which is the relevant clause?
My lord, 7. Clause. It's page number 2, my lord. The first 4-5 lines. The government may accord prior no objection to start a new college in consideration of the recommendation of the Director of Higher Education, which may be communicated to the university concerned with intimation to the sponsoring body of the proposed college. Further, the following instructions shall be given to the sponsoring body for implementation. In view of this, my lord, if we come to Annexure 3, page 31 of the writ petition.
Yes.
That notification has been issued. Page 31, my lord. It is preceded by the Executive Council resolution. It is notified. It was dated 24/5/2022. It is notified for information of all concerned that from now onwards, Guwahati University will accord permission to open new college, stream, subject, after obtaining no objection certificate from the government by respective institutions. Therefore, all concerned who have already applied, they have already applied, writ petition or institution, but are pending for a decision. It's applicable for them. Are hereby requested to submit government no objection certificate in the office of the Director of College Development Council. Also, the college concerned bodies who are interested to open new college stream subject are to submit government no objection certificate along with necessary application, without which the matter cannot be processed. This is issued as per Executive Council Resolution number so and so, dated 29th March 2022. So, my lord.
No, is there any indication in the notification dated 24/5/2022 that this EC resolution was taken pursuant to the office memorandum dated 25th of February 2019.
My lord, it is in the affidavit, my lord. It is clear from the contents of the affidavit that in pursuance to that 2019 office memorandum, Executive Council, the highest executive body of the university, has in the resolution in March and in May, this notification by
Whether that resolution is part of your affidavit?
my
EC
lord,
resolution?
my lord, that EC resolution is not there, my lord. But if required, my lord, I will place the records of that. My lord, resolution.
In which paragraph of your affidavit you have mentioned it?
Paragraph, my lord, 4 and 5. My lord. Paragraph 4 is long paragraph, my lord. And
which portion you sorry?
My lord, particularly in paragraph 5, page 8, my lord.
Page 5. Yes.
Internal page 8. This deponent humbly begs to state that the government of Assam in higher
Okay.
2019, my lord, and in pursuance to that, this March and May notification and resolution has been adopted. Now, if we come to the section 21, I'll cite a decision. My lord. Rashid Javed and others versus State of Uttar Pradesh and another 2010 7 SCC 781. My lord, it's regarding this General Clauses Act of my lord, section 21 of the Central General Clauses Act, my lord, and paragraph 53 onwards.
Paragraph
53 onwards, my lord. That General Clauses Act 1897, my lord, that was quoted, my lord, in paragraph 54. Mary. Paragraph 53, having already held that the order of the hearing authority dated so and so is in excess of the authority given to him, and that the said order has no legal effect, we do not find that there was any impediment for the state government in exercising its power under section 102 of the so and so Act, read with section 21 of the General Clauses Act 1897, to resign the notification dated 16/4/1999. Now paragraph 54. This is the power to issue to include power to add to amend, vary or resign notification order, rules or bylaws. Whereby any central act or regulation a power to issue notifications, orders, rules or bylaws is conferred, then that power includes a power exercisable in the like manner and subject to the like sanction and conditions if any to add to, amend, vary or resign any notification, order, rules or bylaws so issued. You know, the perimeter provision is in Assam General Clauses Act, section, my lord, 23, my lord. Now, paragraph 55. The aforesaid provision came up for consideration before the Constitution bench of this court in Kamla Prasad Khetan versus Union of India, way back in 1957. The majority opinion stated, it is to be remembered that section 21 of the General Clauses Act embodies a rule of construction, and that rule must have a reference to the context and subject matter of the particular statute to which it is being applied. Next paragraph 56. It seems to be barely settled that under section 21 of the General Clauses Act, an authority which has the power to issue a notification has the undoubted power to rescind or modify the notification in the like manner. In the instant case, there is no doubt that the notification dated 15/4/2000 has been made in the same manner as the earlier notification dated so and so. since the order of the hearing authority dated so and so is not an order of approval under section so and so of 88 Act and cannot be treated as such, the power of the state government to resign the notification dated so and so did not get exhausted. The argument that the draft notification dated so and so merged in the order dated so and so is fallacious and devoid of any substance. Now we can skip other parameter, para 60 and 61. Last two paragraph. The contention of Mr. So-and-so learned counsel for some of the appellants that the opportunity of hearing was required to be given to the appellants before issuance of the notification dated so-and-so has no merit for more than one reason. For one, this contention is founded on the premise that order of hearing authority dated so-and-so is the order of state government. Secondly, what section 21 of the General Clauses Act requires is that the authority empowered to issue notification must exercise its power to resign such notification in the like manner. We have already noticed in the preceding discussion that a notification dated so and so has been made in the same manner as the earlier notification dated so and so. Para 61, the concluding part. For the reasons given above, we hold that the notification dated so and so is valid and does not suffer from any legal flaw, and accordingly dismiss these appeals with no order as to cost. So, my lord, as per this section 21, my lord, the university.
Mr. Pukon, there is no doubt that you can issue such a notification. But the question is, what is the basis? What is the reason for issuing that notification? Nothing has been mentioned in that notification. You have supplemented the reason by filing the affidavit in opposition. Is it permissible?
My lord, since my lord EC resolution is there, and if we don't go to the 2019 office memorandum, then also, my lord, exercising the power under section 21, the Guwahati University Authority is empowered to issue that notification. And it is not regarding.
I have already stated you that you have the power to issue notification. But the question is, you have not assigned any reason of why the permission from the state government is required.
My lord, I'll submit from the Act and Regulation, my lord. There are some, my lord, provisions are there, my lord, and the ordinance of the Guwahati University. I'll place one by one. Now, only few judgments, my lord. One division bench of this honorable court, 2017, volume 2 GLT 138. I'll be very brief, my lord, only regarding that policy decision aspect. Last but one paragraph 17. In the middle portion, my lord, fourth line, paragraph 17. It is a settled proposition of law that courts normally would not interfere in the policy-making domain of the government unless the same is perverse, arbitrary, irrational, and without any basis. In the instant case, we do not find that the decision of the respondent authorities in addressing the disparity of pay scale amongst workers, computers, so and so, suffers from any infirmity. So, my lord, regarding non-interference in the policy decision, my lord. And another case is also there, my lord. State of Punjab versus Oniska Goyal and others. Only one parameter, para 9.2. I think it will be sufficient regarding the policy decision, my lord. Only that judgment, my lord. Paragraph 9.3. In the middle portion, my lord, paragraph 9.3. That 25, my lord. That subpara starts from interference. Interference with the policy decision and issue of a mandamus to frame a policy in a particular manner are absolutely different. The Act has conferred power on the central government to issue notification regarding the manner in which the census has to be carried out. And the central government has issued notifications and the competent authority has issued directions. It is not within the domain of the court to legislate. The courts do interpret the law, and in such interpretation, certain creative processes involved. The courts have the jurisdiction to declare the law as unconstitutional. That too where it is called for. The court may also fill up the gaps in certain spheres applying the doctrine of constitutional silence or abeyance. But the courts are not to plunge into policy making by adding something to the policy by way of issuing a writ of mandamus. I think it will be sufficient, regarding the empowerment, the power of the university authority to, frame their own policy decision. Now I beg to draw your lordship attention to the act. NCPA.
Which act?
1993 NCPA Act. Section 14, subpara 4. The page numbers are down below, my lord. It is in page 8, my lord.
All right.
In the middle portion, my lord, 4. Every order granting or refusing recognition, that word is important, my lord, that recognition. My lord, I'll focus upon that word, my lord. Recognition to an institution for a course or training in teacher education under subsection 3 shall be published in the official gazette and communicated in writing for appropriate action to such institution and to the concerned examining body, that is the Guwahati University, my lord, the local authority or the state government. State government is also here, my lord, and the central government. So, my lord, that recognition part, that would be in the official gazette. It would be issued by the NCT authority. And if we turn to that judgment of 2006, that judgment is post recognition by the NCT authority. My lord, I'll refer paragraph 80 of that judgment, my lord. My lord, Sen Dhyan Sen, my lord. Paragraph 80, my lord. State of Maharashtra versus Sant Dhaneshwar section, paragraph 80, my lord. Last 4 paragraph, my lord. Entire judgment is regarding post recognition period. But here the petitioner is in the pre-recognition period without any official gazette publication regarding the recognition. It is in the pre-recognition stage regarding affiliation by the Guwahati University. Para 80, my lord. Only that para. I think that will be sufficient, my lord, that the judgment is not applicable in the instant matter. Paragraph 80, my lord. In our
Problem
opinion,
is that in this judgment, there is no paragraph. This is downloaded from the judice.nic.in.
my lord, it is SCC. That's but one page, my lord, para 80. May I read, my lord? In our opinion, the observations that the provisions of section 82 and 83 of the Maharashtra Universities Act are null and void would not be said to be correct. To us, it appears that what the High Court wanted to convey was that the provisions of section 82 and 83 would not apply to an institution or covered by 1993 Act. It is important, my lord. As per the scheme of the Act, once recognition has been granted by NCT under section 14(6) of the Act, every university, that is examining body, is obliged to grant affiliation to such institution and section 82 and 83 of the University Act do not apply to such cases. So it is after recognition, my lord, the university cannot, my lord, hold back that affiliation process.
No, in their case, NCT has not granted them recognition.
No, my lord. It is, my lord, pre-recognition period, my lord. That recognition would be published in the Gazette, my lord, notification, my lord. It would be published and that recognition would be granted, my lord. After that, my lord, no university can hold back that affiliation, my lord, process. That is the, my lord, ratio. That is the decision of the Supreme Court in this Dearness case. And it is totally not applicable in the instant matter. My lord, now, if we come to the rules, my lord, that is very, very important. This act is regarding recognition process, not the rules. Rules of 2014. NCT Regulation 2014. Rule 7, sub rule 4. Rule 7, page 93, down below. It's regarding processing of application. 1. Now, finally turn to 4, next page. A written communication, para 4, para 4 onwards, 4 to 7. A written communication along with a copy of the application form submitted by the institution shall be sent by the Office of Regional Committee to the state government. So that NOC from state government, Miller, it is provided in the rules itself to the state government or the Union Territory Administration and the affiliating body concerned within 30 days from the receipt of application in chronological order of the receipt of the original application in the regional committee. Next, again, Miller, the role of state government, Miller. Why the NOC from state government is required, Miller? The rules are clear. Next, para 5, sub-para. On receipt of the communication, it is important, Miller. The state government or the Union Territory Administration concerned shall furnish its recommendation. So that NOC aspect, Miller, it is also clear from this sub-para 5. Now, if we skip to sub-para 6, again the role of state government. The sub-para 6. The recommendation of the state government is not received within the appropriate period. The regional committee concerned shall send a reminder to the state government. Now, Milord, we can skip again, Milord, to up to now 7, Milord. After consideration of the recommendation of the state government or in its own merits, the regional committee concerned shall decide that institution shall be inspected by a team of experts called visiting team with a view to assess the level of preparedness, etc., etc. So, first that NOC from state government, then the inspection by the regional committee of NCT, then recognition. And before that, since state government's NOC would be required, so that is why that policy decision has been taken by the Guwahati University that NOC from the state government is required. And it is more so in view of the FIR registered in 2020 in Nagaon Police Station, regarding the principal and director of the PAMEC institution of BA and LLB course. So, if we skip those FIR episode, then also, the state government's NOC would be required, as per subsection 4 to 7. Now, if we turn to subsection 13, sorry, sub-rule 13, next page, same rule. Sub-rule 13, the institution concerned shall be informed through a letter of intent regarding the decision for grant of recognition or permission subject to appointment of qualified faculty members before the commencement of academic session. The letter of intent issued under this clause shall not be notified in the Gazette but would be sent to the institution and the affiliating body with a request that the process of appointment of qualified staff as per policy of state government. Again, the role of state government. The faculty should be appointed as per policy of the state government. Or university grants commission or university may be initiated and the institution be provided all assistance to ensure that the staff or faculty is appointed as per the norms of the council within 2 months. The institution shall submit the list of faculty as approved by the affiliating body to the regional committee. So, my lord, the state government role is clear from the act as well as rules, particularly the rules of 2014. Now, if we turn to the Supreme Court cases, my lord, where the role of the state government is, my lord.
No, in the HCT Act, is it provided regarding the NOC from the state government?
No, my lord, it is, my lord, only the recognition and permission by the NCT. It is the act provision that 14.4 and 14.6 is confined to only to that extent. Thereafter, my lord, that 2014 rules under that act, that rules provide how to, my lord, affiliate or how to, my lord, that recognize or permit the institution concerned under NCT or affiliating university. So rule 7.4 onwards up to 13, it is clear that state government rule is there. My lord, if we turn to the my lord, Supreme Court cases, my lord, then the state government's role, my lord, will be clear.
Okay.
First one, my lord. Others, Shiksha, Mahavidyalaya and others. There are 7 and 64. The background, my lord, regarding the B.Ed course. There are 7, my lord. Page 437. In the middle portion, my lord. Mary. We have prefaced the disposal of these appeals, which are directed against the interlocutory order dated so and final order dated so passed by the division bench of the Madhya Pradesh High Court in so case, and connected matters by highlighting the need for well-equipped and trained teachers, because in the last 3 decades, private institutions engaged in conducting teacher training courses programs have indulged in brazen and bizarre exploitation of the aspirants for admission to teacher training courses, and rank commercialization and the regulatory bodies instituted under laws enacted by Parliament and the state legislatures have failed to stem the rot. The cases filed by these institutions, many of which have not been granted recognition due to non-fulfillment of the conditions specified in the National Council for Teachers Education Act 1993, for short 1993 Act, and the regulations framed thereunder, and by the students who have taken admission in such institutions with the hope that at the end of the day, they will be able to get favorable order by invoking sympathy of the court, have shocked the dockets of various high courts and even this court. The enormity of litigation in this field gives an impression that implementation of the provisions contained in the 1993 Act and the regulations framed hereunder has been acutely deficient, and the objects sought to be achieved by enacting the special legislation, namely planned and coordinated development of the teacher education system throughout the country, the regulation and proper, next page, Lord, maintenance of norms and standards in the teacher education system have not been fulfilled so far. This is the context, Lord, why the Supreme Court has, Lord, answered into that answer. Now, we can skip other para 64. Para 64, page 475. The last portion, Para 6.4. If the High Court had not ordered re-scrutiny of the recognition affiliation granted to the private institutions, the irregularities committed by the Western Regional Committee, here Eastern Regional Committee, Western Regional Committee may never have seen the light of the day, and we do not see any reason to nullify the exercise undertaken by the High Court to ensure that the provisions of the 1993 Act and the regulations thereunder are strictly followed by the authorities entrusted with the task of granting recognition and affiliation to the institutions and colleges engaged in conducting teacher training courses. Now, we can have para 87.11. Prior to that, para 77. Para 77, 482. Only 5 lines. Para 77. The last portion. Para 77. The above survey of precedents makes it clear that under regulations 7, 2, and 3, the state government, union, territory administration is entitled to make recommendation on the application made for grant of recognition, and the same are required to be considered by the regional committee concerned before taking a final decision on the application. So the role of state government or the union territory administration for making recommendation, and after that, the regional committee will confer the recognition or permission. It is clear. Now, the last parameter 87.11. Para 87, sub para 11, Roman 11. It is page 485, down below, para 87. As a sequel to the above discussion, we hold that the impugn orders do not suffer from any legal infirmity warranting interference by this court. We also reiterate that we can skip other para 11 page 487, sub-para 11. While granting affiliation, the examining body shall be free to demand rigorous compliance with the conditions contained in the statute like the University Act or the State Education Board Act, under which it was established, for the guidelines, norms which may have been laid down by the examining body concerned. I'll place the ordinance a little bit later. So, that before granting affiliation, the university authority may free to demand rigorous compliance, so that NOC also includes that rigorous compliance. And now another very, very important Ma Vaishno Devi Mahila Mahavidyalaya case, 2013 2 SCC 617. Para 52. Page 643. In the middle portion.
Paragraph number
52. Under the scheme of the NCT Act, there are 3 principal bodies involved in processing the applications for grant or refusal of recognition for running of teacher training courses by various institutions. They are 3 bodies, First, NCT. Second, the state government. The role of state government is clear. First, NCT. Second, state government. Third, the affiliating body or the university, as the case may be. Each of these stakeholders has been assigned a definite role under the provisions of the NCT Act and even the stage at which such role is required to be performed. The provisions of the NCT Act even identify the scope and extent of power which each of these bodies is expected to exercise. As already noticed, the NCT Act has been enacted with the object of constituting a national council with a view to achieve planned and coordinated development of teacher education system throughout the country, and also to ensure maintenance of proper norms and standards in teacher education system. NCT is a specialized body that is expected to perform varied functions, including grant of recognition, ensuring maintenance of proper norms and standards in relation to teacher education, inspection of the colleges through experts, and to ensure strict adherence to the time schedule specified under the NCT Act and the rules and regulations framed thereunder. Now, para 70 and 71. Para 70, page 653. Under section 14, and particularly in terms of section 14(3)(a) of the Act, NCT is required to grant or refuse recognition to an institute. It has been empowered to impose such conditions as it may consider fit and proper, keeping in view the legislative intent and object in mind. In terms of section 14(6) of the Act, the examining body shall grant affiliation to the institute where recognition has been granted. In other words, granting recognition is the basic requirement for grant of affiliation. Here, recognition has not been granted as yet. It cannot be said that affiliation is insignificant or a mere formality on the part of the examining body, that is Guwahati University. It is the requirement of law that affiliation should be granted by the affiliating body in accordance with the prescribed procedure and upon proper application of mind. Recognition and affiliation are expressions of distinct meaning and consequences. In Bharatiya Education Society so-and-so, this court held that, under quotation mirror, the purpose of recognition and affiliation is different. In the context of the NCT Act, affiliation enables and permits an institution, next page, to send its students to participate in public examinations conducted by the examining body and secure the qualification in the nature of degrees, diplomas, and certificates. On the other hand, recognition is the license to the institution to offer a course or training in teaching education. The court also emphasized that the affiliating body, examining body, does not have any discretion to refuse affiliation with reference to any of the factors which have been considered by NCT while granting recognition. It is after recognition. Now, para 71. The examining body can impose conditions in relation to its own requirements. Here, the Guwahati University. These aspects are eligibility of students for admission, conduct of examinations, the manner in which the prescribed courses should be completed, and to see that conditions imposed by NCT are complied with. Now it is important below. Despite the fact that recognition itself covers the larger precepts of affiliation, still the affiliating body is not to grant affiliation automatically, but must exercise its discretion fairly and transparently while ensuring that conditions of the law of the university and the functions of the affiliating body should be complemented to the recognition of NCT and ought not to be derogation there. Now, para 80. Page 656, down below, para 80. That San Dearness case has been distinguished here. In San Dearness case, this 2006 case, my learned senior friend has already referred to. The view of this court was that the state government has no role whatsoever. However, in Bharatiya Education Society, it is later decision in 2011. It was stated that the role of the state government was limited to the manner of admission, eligibility criteria, etc., without interfering with the conditions of recognition prescribed by the NCT. The exercise of discretion by the state government and affiliating body has to be within the framework of the Act, the regulations, and conditions of recognition. Even in St. John's Research Training Institute, it is of 2003 case Miller. The court stated that the state government or the union territory has to necessarily confine itself to the guidelines issued by the NCT while considering the application for grant of no objection certificate. It is Miller clear that NOC from state government. Minimization of the role of the state at the second stage can also be justified on the ground that affiliation primarily is a subject matter of the university, which is responsible for admission of the students, laying down the criteria thereof, holding of examinations, and implementation of the prescribed courses while maintaining the standards of education as prescribed. Now, para 88 and 89. Page 660. Para 88. In all the appeals and petitions before us, the basic issue is whether the university and the state government were justified in rejecting the application or not granting application for affiliation on the ground that there was a cutoff date and or the conditions of recommendation affiliation had not been satisfied. So that role is clear here. That power is to be exercised by the university as well as the state government. In some cases, serious disputes have been raised with regard to the fulfillment of the conditions of recognition and or affiliation. As far as the reason in relation to cutoff date is concerned, we cannot find any fault with the view taken by the authorities concerned. 10th of May has been provided as the cutoff date, after which no affiliation for the current academic year will be granted. This being the law stated by this court is binding on all concerned, including any authority. The authorities have rightly acted in declining to entertain and or refusing affiliation to the institutions being beyond the cutoff date. Adherence to the civil was the obligation of the authorities, and the institutions cannot raise any grievance in that regard. The said time schedule must become operative in all respects, and nobody should be permitted to carve out exception of this mandatory direction. Now, para 89. Coming to the cases where the plea has been taken by the respondent university state that conditions of affiliation have not been satisfied, it is not for this court to examine the compliance or breach of conditions and their extent in the special leave petitions or writ petitions, as the case may be. In fact, the judgment of the High Court has been brought to our notice, where it has been recorded that conditions in some cases have been complied with, but still the state has taken the stand that besides cutoff date, other conditions are also not satisfied. One of the examples relates to the matter where the state affiliating body has found that even the building's boundary wall was not complete and the fire equipments have not been installed as prescribed. However, these were specifically disputed by the petitioner's appellants, who contended that all conditions had been satisfied. Thus, these are disputes of very serious nature. They will surely fall beyond the ambit of appellate or jurisdiction by this court. This is for the specialized bodies to examine the manners upon physical verification and to proceed with the application of the institute in accordance with law. Now, para 91.3 and 91.4, the last para. Last but one page. Page 662, last 4 lines. 91.3. We hereby direct NCT state government examining or affiliating body. The direction was issued, including state government, to consider the applications and pass appropriate orders granting or refusing to grant recognition affiliation to the petitioner institutions within 3 months from today. So the applications have been sent to the state government. Next, para. If the institutions are aggrieved from the order passed by the authorities in terms of clause 91.3 supra, they will be at liberty to challenge the same in accordance with law. So, the state government NOC aspect, is clear from these judgments, my lord. And 97th ordinance, the Guwahati University. My lord. What it provides, my lord. Rule 7, clause 7(3). Page 3, my lord. Designations down under, my lord. 3. 7. Permission to establish new college. 3. The Executive Council on receipt of necessary concurrence from the state government. So here also, my lord, that concurrence from state government. So that policy decision regarding NOC from state government, it is in tune with this provision, my lord. The Executive Council on receipt of necessary concurrence from the state government shall accord permission to establish the proposed degree college and shall issue necessary directions to the sponsoring body, the writ petitioner, my lord, to implement the following requirements under time-bound period. So we can skip other parameter. Now, if we come to the affiliation parameter. 24. Clause 24. Permanent affiliation. Page 15.
No, this permanent affiliation will come only after temporary affiliation.
Temporary affiliation.
So temporary affiliation is yet to be granted.
My lord. So before temporary affiliation, that establishment of new college, my lord, that clause 7(3). So state government conference would be there, my lord. So, my lord, these Supreme Court's judgments, particularly Vaishno Devi and the NCT Act and regulations, are clear that the state government's role would be there. And as per that, my lord, policy decision has been taken by the university authority that NOC from the state government will be required by the writ petitioner institution. That is my submission. And since it's a policy decision, my lord, so that UGC versus Nehaunil Bobde case is also there, my lord. Academic matters, my lord. That would be best left to the, my lord, concerned, my lord, experts. My submission.
But the decision which Mr. Buragohai relied upon is the decision of constitutional bench. The decision referred by Mr. Buragohai is a constitutional bench decision, but and the judgments you have referred to are two judge bench decisions.
My lord,
And my lord, this act has been enacted in 1993. The judgment is 2006, so fully covered. Man. After this enactment, the judgment has come. But it is not that it is a pre-existence of the
2006
number 2, my lord.
Two judges bench.
2 judges and
2006,
constitutional bench.
3 judges, sorry, not a constitutional bench.
3 judges. Then it has been, my lord, distinguished by the later pronouncement, my lord. I have already referred, my lord. And particularly,
as a
one aspect,
short, my lord,
particularly
reply.
since it's post-recognition periods petition. Supreme Court is on post-recognition. If it has been already been recognized or permitted by the NCT by publication in the official gazette, then, my lord, no university can hold the affiliation process. That university also includes state government. No authority can hold that affiliation process. But here, no recognition has been granted. In earlier case, your lordship will remember, recently, my lord, judgment has been delivered by your lordship, my lord. My lord, in that case, recognition has been already conferred by the NCT. That is why those students, 64 students, have been allowed to, my lord, take part in the examination and to declare the results. But the other directions are, it has been sent to the NCT for their decision, and thereafter, Guwahati University will take this on the, my lord, status of that college. It was recently, my lord, passed in WPC number. My lord,
Your lordship made first the judgment. Nothing.
But that was still in different footing. That was post-recognition period. But it is pre-recognition period.
So admittedly, Mr. Buragama, you have not applied to the state government for grant of NOC.
My lord. Here not, my lord. Our case is that he has read, my lord, section 14 of this act, my lord. National Council for Teachers Education Act 1993. And here, my lord, he read only one paragraph, leaving the main paragraph 5 and 6. He read up to 4 only.
Okay.
My lord, your lordship will see that also. And secondly, my lord, we are only concerned in this particular writ petition about the conflict between Central Act and the State Act. And here, when there is a Central Act and that has been made under NT 66 of Union List, that is, my lord, that cannot be interfered either by state or by university or by anything. That can be only interfered by legislation by the central government. And
But
for that,
there is a mention in the rules of that act about this NOC from the state government.
my lord,
In the act of that, no, in the rules of that act,
that
there is a
act
reference to-
specifically says that when recognition is a subject under section rule 13 or rule 14, it is exclusively under the domain of the act, not for we are the state government nor the university can amend it by saying that you take NOC from so and so, so and so. They will decide whether they will give or not. That is our contention. And my lord, my lord, I do not, because the time is very short, I do not, there are only the paragraph numbers I have indicated. Your lordship, I'll pray your lordship to go there.
Okay. Partner sir is a program, learned senior counsel assisted by Ms. Your good name, please, madam.
Zeb Tamuli.
And Mr. Popon, learned standing counsel for the Guwahati University. Argument compromise order in the.
Obligement.
Mr. Popon, the other respondents are not available.
Milord, the matter may come up on tomorrow or day after tomorrow, Milord. It's that judgment referred by my learned friend was par incuria. Milord, without citing the proper act and provisions of the Guwahati University. And further, Milord, the fact situations are different. Here, Milord, there is no reason cited, Milord, but in that case, marriage and childbirth, Milord, two equity consideration was there. And without considering the relevant provision of the act and the notification and rules, Milord, that order was passed. So as per Supreme Court's several decisions are there, Milord, I will cite, Milord. I have got the decisions, Milord. It's a par incuriam judgment. So it has got no binding effect. It is only for equity consideration, Milord, that order was passed. And here, Milord, no reason, no ground has been cited. He has exhausted the petitioner. She has exhausted all the 4 chances within 8 months. So the matter may come up without hearing my learned friend, Milord. It would not be proper, Milord. I won't insist, Milord. So tomorrow or day after tomorrow. That item number
NCD
5 issues. I'm sorry, Milord. I'm regarding item 6, Milord. I thought that item 5 is complete, Milord, that hearing. Judgment reserved then.
That's all right, but the other standing counsel for the other respondents.
Item 5.
Mr. Sisti, are you appearing in this item? Okay.
Item number 31, fixed at 2 p.m. Bail hearing matter.
Yes, Mr. Portakor.
Yes, my lord, yes, I have gone through the judgments, my lord, and now the position is very clear, my lord. My lord, the petitioner is not entitled to get benefit in view of the, my lord, judgment of the Pankaj Bansal and in view of the prospect effect of the judgment of the Pankaj Bansal. And thereafter, my lord, in fact, the judgment of the Pankaj Bansal is still said that henceforth the effect of the Pankaj Bansal is prospective. And thereafter, the same fact was confirmed by the, my lord, judgment of Ram Kishore Arora. And those, my lords, my submissions, in some two of the honorable, my lord, coordinate bench of this High Court also, my lord, accepted the arguments, my lord, that, my lord, that judgment of Pankaj Bansal is prospective. And before areas after, that is 310/23, the petitioners are not entitled to get the benefit of the judgment. So, my lord, I would like to point out that. Regarding other issues, my lord, your lordship has already decided, my lord. The point left only the present issue, my lord. So. I'm just pointing out, my lord, in one of the judgments of the coordinate bench, my lord, although at that point of time, that, my lord, date of arrest was after Pankaj Bansal, that in that view of the matter, the petitioner was granted bail, but my argument was accepted, and I would just like to point out, my lord. Paragraph 9. That observations of the on the relevant portion I am reading out, my lord. That the observations of the apex court in the case of Pankaj Bansal versus Union of India regarding furnishing the grounds of arrest in writing is applicable only prospectively. Still, it may not help the state in this case, as the judgment in Pankaj Bansal versus Union of India was delivered on 4/10/23, whereas the present petitioner has been arrested on 17/2/24. So in that case, my lord, although bail was granted, because my lord, petitioner was arrested prior to 3/10/23, but that observation was made. And in another, my lord, judgment of this coordinate bench of this honorable court, my lord, paragraph 24 to 27, which was pointing out, paragraph 24, my lord. It would be worthwhile to mention that the apex court has held in the case of Pankaj Bansal versus so reported in so that grounds of arrest must be communicated in writing to the accused. However, the case of Pankaj Bansal can be made applicable only to arrest made after the said decision rendered by the apex court on 3/10/23. Your lordship may kindly. Both the paragraphs. In this case, also petitioner is also not entitled to get the benefit of.
Yes, so Mr. Ahmed, anything to submit?
If your lordship is taking up bail application number 1100, that order, lordship. passed by coordinate bench, Lordship may kindly consider paragraph 22 and 23 also of that, because my learned friend has relied on paragraph 24.
24 to
22 and
27.
23 specifically said that information has to be given to the accused. And in fact, that bench itself also granted bail to one of the accused. He was arrested on 25/3/2022. And the arrest memo and inspection memo as well as notice is similar to my case. I'm just handing over to your lordship.
And well, I would like to again point it out, the case of the petitioner is not that he was not informed of the grounds of arrest. Now,
What arrest?
at any point of time, he has raised the ground that he was, my lord, not even informed about the
Lordship may
grounds of
kindly
arrest,
say the
because
judgment which-
Section 50 and arrest memo is there in, my lord, in the petition itself.
Here, lordship will find paragraph 9, 11 and 12 regarding that notice, arrest memo and inspection memo are quoted here.
That's all right, but whether this aspect of the observation made by the Supreme Court in the case of Pankaj Bansal was pointed out to the court at that point of time?
No, lordship, those were not considered because that Prabir Purka, even in fact, the judgment which is relied on by my learned friend, that bail application number 1100, here also no reference was made to Prabir Purkasta or lordship to the Supreme Court constitutional bench judgment, lordship. Those reference is not there.
Regarding the constitutional bench judgment.
Here only Pankaj Bansal was relied, lordship. Subject to correction, what my learned friend says, and here I have relied on Prabir Purkasta judgment, that's it. And Najimuddin, which order was passed, and that also Bihan Kumar, relying on Bihan Kumar, that order was passed, which the order which I have handed over to your lord. And in my case also, if your lordship see the forwarding report, it also says, lordship, grounds of arrest were communicated by issuing the notice. That your lordship will find page 19. For page 19 of my bail application. Okay.
Will pass the order.
Lordship. Oblige.
Number 14.
Then, my lord, I would like to one another aspect of the matter, my lord. In this case, the father of the petitioner was arrested on 18/7/23. At that point of time, petitioner was, my lord, he fled away. Thereafter, my lord, on my lord, 2/2/23, the present petitioner was arrested. So, my lord, presumption is also that, my lord, petitioner is already know the reasons, my lord, already why his father was arrested, and from his possession, my lord, those contrabands were recovered. And otherwise, my lord, in Pankaj Bansal itself, my lord, order from the order itself reflects that henceforth, my lord, the judgment itself says that this judgment will be effective. Paragraph 41, my lord, very clear, my lord. And that, my lord, this judgment is on effective only prospectively.
And regarding clear, that part is not there in the FIR.
Item number
Oblige.
15.
Can it be taken up, my lord, on Wednesday next, my lord? It will take some time, my lord, regarding.
In fact, my lord, can it be on next Tuesday, my lord? In some time will take this matter, my lord. Tuesday, my lord.
Okay. Yes, agreed by learned advocates of both the parties, restrictions are less than matter on Tuesday.
Item 16.
Oblige.
May I please, your lordship? My lord, this matter pertains to my lord, the compassionate ground appointment. Well, the petitioner's husband had expired in the year 2001. He was a grade 4 employee in a girls' high school, Katlichla Girls' High School, and thereafter she had immediately applied. And during the period she was working, my lord, page number 9 onward, my lord, her application after the death of her husband. She was honorary working, my lord, in the school. And by resolution of the managing committee, page number 11. Honorably, she was engaged. Well, page number 11 is the second resolution is the resolution managing committee. And thereafter, madam, page number 13 is the head mistress engaged her on honorary basis, my lord. It is one aspect, my lord. And subsequently, my lord, page number 16 was her application for compassionate appointment was forwarded by the inspector of schools. And during this period, my lord, page number 17 is her working experience certificate. Page number 16, my lord, is the application forwarded. And 17, 18, her working certificate issued by the headmistress. Now, my lord, in the meantime, my lord, this the state government had issued an office memorandum, my lord, that is not a part of this writ petition on 18/9/24, my lord. That before 31/3/17 cases will not be considered, my lord. And that was challenged before this honorable court, my lord. And this honorable court, my lord, by the judgment in a series of judgment, my lord. My lord. Abdul Qadir Bakshi. In Abdul Qadir Bakshi case, my lord, paragraph 5. Paragraph 5, my lord, in a series of writ petitions on different grounds, the writ petitions are filed. And in some of the writ petitions, the OM of 18/9 was challenged, my lord. And this honorable court operating paragraph. And in Abdul Qadir Bakshi case, operating paragraph is paragraph 9, my lord.
One that similar order may be passed.
Yes, my lord. On Abdul Qadir Bakshi, my lord, another case, Nazrul Islam Chaudhary disposed of by this honorable court, my lord. So,
yes, Mr. Kosek, any
it is covered.
Before this order, in the last paragraph of that order, the cutoff date is given, 4/4/2024. This is
But
filed
this
prior to-
application was prior.
filed prior to-
Prior.
We dispose of this.
Obliged.
17.
This case relates to non-payment of arrears salaries, my lord.
I've received the instruction today, my lord. I'd like to file my affidavit. 3 weeks time maybe.
Well, the date may be given, my lord. Otherwise, case will not be listed.
Part Miss Kedebel or not for for
for 29, no?
elementary education. Elementary education.
Elementary.
Yeah, my lord. Secondary.
Secondary.
Education department.
Amalgamation.
Mr. Kosik submits that he has received instruction and he will bring the same on record by way of an affidavit and price for granting in 3 weeks time. Care is allowed. Place the matter on
29, my lord. May. Hello, bless.
Yes.
Oh, yes, yes.
So item 21, I'm appearing to fix a sale. And I have,
my lord, let me start, my lord. Here, Lord Sir directed me to file my affidavit. My lord, affidavit was served, my lord. Even affidavit was taken to the registry for filing, my lord. A technical defect at 15 in the affidavit, my lord. That paragraph, my lord, phone number has not been missing, my lord. That's why it cannot be filed, my lord. Lord Sir, allow me some time that portion had to be added to the affidavit, my lord. I have already
filed the affidavit.
No, I have served the affidavit to one of my friend, my lord, Mr. Ali, my lord. But it has been because it will cover the entire all the cases, my lord. And affidavit was registered at registry to filing, my lord. Then the error kicked in, my lord. That was shown to me that there is an error in the affidavit.
But you will be able to file the corrected affidavit.
Lordship will allow me some time, my lord.
Next week, my lord.
Means
Today is 14th, my lord. Let it be on 20th, my lord. 20.
20,
20, my lord.
20.
20. I will file. In the meantime, I will make that particular correction. I have to make it, my lord. I have not received any copy, Lordship. No, it was filed on his. Because it was here, my lord. I was ready with the copy, my lord. That I have withhold it.
Heard Mr. S.K. Goswami, learned counsel for the petitioner in WPC number 1991. 2024, Mr. S. Ali,
Yes, my lord. Item number 18 and 19 and 22, Lordship.
WPC number 1735 of 2024 and 1736 of
Yes, Lordship.
2024 and
2339.
2339 of
Yes, Lord.
2024 and Mr. Professor for petitioner in WPC number 1856 of 2024. Also heard Mr. S. Bora, learned
BTC, my lord, standing on.
standing counsel for the PTC. Mr. Bora, learned standing counsel for the PTC submits that he has already prepared his affidavit and survey copy of the same to Mr. Ali, S. Ali, but he could not file the same in the court as some mistake has been committed. And he may be
Some
and
technical
effect
error, my
for
lord.
granting him some time to file the corrected affidavit. Where is accordingly allowed, list the matter on. $27.
Lordship, urgency is there, so some are going to retire from service. So, yes,
Okay, but this petition is of 2024.
that is why, Lordship.
27.
Lordship, I'll do it.
Item 21, there is an interim order that's continue.
Pardon?
Item 21, there is an interim order. That's
Interim order passed in, item number 21, self-control.
obliged, Lordship.
Item number 23.
Lordship, my lord, I have received the rejoinder filed by the petitioner. I have sought for instruction from the university. I pray that the matter may be listed on Monday. I wait for the instruction from the university.
When the matter may be listed?
Monday, my lord, next week, any day.
Next week. Okay. Art Miss
S. Musahari, my lord.
S. Musahari, learned counsel for the Dibrugad University. No. For the petitioner.
Petitioner, my lord.
And Madam,
Iwa Pangla,
learned counsel appearing on behalf of Mr.
R. Mazumdar, my lord.
Mazumdar, learned standing counsel for the respondent, Dibrugad University. The learned counsel appearing on behalf of Mr. R. Mazumdar, press for listing the matter on
Next week, my lord, any day.
23rd.
23rd will be late. Monday, my lord. On 19th
Okay, 19.
of August.
Item 24.
None appears for the petitioner on call, list the matter after a week.
25.
This is your lordship. Your lordship, on the earlier occasion, the respondent authorities, more particularly respondent number 3 and 6, sought time to bring in some instruction, lordship. In that regard, till date, they have not
My lord,
produced any
the thing is that it's still before the Vigilance Committee of the Madhuri Patil, the Supreme Court appointed committee, my lord, Madhuri Patil committee. So once the Vigilance Committee sends the report to the state level scrutiny committee, then only state level scrutiny committee will take time. My lord, verification of a caste certificate, it takes some time because they have to go to the Vigilance Committee, they have to go to the root. So my lord, it is still under investigation. So my lord, it will take some time. My lord, let this matter may come after 4 weeks. Today I have spoken to the chairman of the state level scrutiny committee, my lord. They said that they have instructed, my lord, the Vigilance Committee to wind up the, my lord, investigation as soon as possible, my lord. But my lord, this is the way it is, my lord, because it takes some time. Because by this way, my lord, somebody's status will be taken out.
If I may, Lordship, that being said, Lordship, the order is dated 12/6/24, Lordship, last year. They were to bring in instruction, Lordship.
My lord, whatever I said, well, this is the instruction, my lord.
After 2 weeks, Lordship.
My lord, let this matter come after 4 weeks.
Heard, Mr.
Jai Lotha,
Learned counsel for the petitioner.
petition.
Then also heard Mr. Ardhor, learned standing counsel for tribal affairs. For respondent number 3 and 6, and 3 and 6, Mr. Ardhor submits that the matter may be listed after
4 weeks.
4 weeks. As the matter is under scrutiny of the Vigilance Committee.
Vigilance Committee, of the
Vigilance
State
Committee.
Level Scrutiny Committee, man.
Vigilance Committee and
Of State Level Scrutiny Committee.
of State Level Scrutiny Committee. Accordingly, there is accordingly allowed, list the matter after 4 weeks.
Lordship, may I pray for a date, Lordship?
Pardon?
A date, Lordship.
Interest.
Date.
Date.
Yes, Lordship.
22
Highly obliged.
27.
Okay, I'm sorry, Lord. I was in 24. I was in put number 1. I couldn't get it in time. Simple case, Milord. Here, the petitioner sought transfer. He was working in the district of Nagaon. Comment কোন আছে? Education. And the rule states that there is a rule, there is an act, Milord, stating Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Rules. Transfer Act, Milord, of that was original act was of 2020.
Who is for secondary education department? Anybody for secondary education department?
Education.
24.
24.
Here we are awaiting instruction.
I think instruction is not necessary. It is on the basis of the act only. Act states, Milord, if after working for more than 10 years, he can seek transfer from the government. And accordingly, the government, he gave application. Accordingly, government sent it to the committee to see whether there is any school, there is vacancy in the district, because I sought for transfer to the Morigaon district. That was my home district. Rule states this way, Milord. Rule section 7. I have quoted also that in my petition. At paragraph 4, I have stated, Milord. Page 5. Section 7, last line, section 7 will say that at page 5, Milord, beginning, provides that inter-district transfer norms of teachers. The provisions for section 2 is reproduced below. The government and the competent authority shall be guided by the following norms in respect of inter-district transfer. A teacher working in a district continuously for 10 years or more can apply for transfer to his or her district or to a nearest, that is home district, or nearest contiguous district. On that basis, Milord, and that provision was amended in 23, Milord. only some contiguous district is amended.
Hmm.
Then your lordship will see then section 11 states, my lord, at page 6. There says section under 11, transfer not to affect seniority, provided that transfer of a teacher is made under this act shall not in any way affect the original seniority of the in the respective cadre of service. 11 states that were, my lord, and in spite of that, when I sought transfer and transfer was given, the impugned order, your lordship will see at page Annexer D, page 19. Yes. Clause 8, my lord, last column before signature. The teacher concerned shall not claim seniority over the existing staff of the newly posted school. On reporting in the school allotted to the district level committee and the newly posted district, the seniority of the teacher will be determined from the date of his reporting in the school. So my contention is when section 11 says that seniority will not be lost, how can that order be passed, my lord? Because only in mutual transfer, to my understanding, Lord, the seniority is not granted. Or transferred below 10 years. But when it is transferred up more than after 10 years, my lord, No, main con. Main con was 2020. In section 10 of the Act, my lord, grounds for seeking transfer is there. And in clause E, for the reasons mentioned in section 7, it is mentioned there. And section 11 says, the transfer of teachers made under this act shall not in any way affect his or her seniority, original seniority in the respective cadre of the service. So section 10 says under section 7, I can seek transfer, and 11 says seniority not list. Even after that, Milon, by this impugned order, they have said then I lose my seniority.
Yes, Mr. Kochi.
But the transfer, this is a transfer on our own request. And the petitioner, my lord, she was provincialized on his entry into service is 1/1/2013. And immediately thereafter, he has applied for transfer after completion of 10 years. My lord. His application is 23/8/2022.
After completion of 10 years?
No, prior completion of 10 years, he have filed his application.
So maybe he may file the application, but you have to consider only after 10 years.
My lord. His application is 23/8/2022.
No, maybe, but the order was passed after 10 years.
My lord.
So is the condition at
in
clause 8 of the order, transfer order,
My lord.
is contrary to the provision of section 11?
In section 3, I have given, my lord.
Will give me some time.
At section 3, I have given when I have joined. At paragraph 3, my lord, page 4. That school in the original by 2011, Service Act were created and provincialized. The Sutangao,
So
Utargao,
effect from 1/1/2013, he was provincialized.
yes,
Provincialized. And
1/1/13.
his transfer order was passed on 2nd of August 2023 after 10 years.
After 10 years, yes. I applied for after 10 years.
No, application is prior, before 10 years.
No.
Yes, madam. Application is page 18, madam. Submitted on 23/8/2022.
Maybe.
Though the ground is shown to be have completed 10 years of service, madam, in the application. The lordship will give me some time, let me examine.
In paragraph 4, I have
Maybe next
stated,
week.
Milord. The petitioner's name appeared at serial number 6 as assistant teacher of the school, showing the date of joining as 10/12/2007.
So,
This error was
possibly,
communicated.
is there anything to be examined here? Because the section is clear.
Yes.
Anyway, if you want to examine the matter, let it be on Friday.
Friday.
My lord.
Third Mr. DP Solihan, learned senior counsel assisted by Mr.
UP Chalihan.
Learned counsel head of the petitioner and Mr. P. Kosik, learned standing counsel for the respondent.
Secondary.
Secondary Education Department. Third is the matter on Friday.
My lord.
27.
May I please, your lordship, my lord, on last occasion, lordship, it was submitted, lordship, that instruction was received and they are going to file the affidavit, lordship.
Lordship, may I pray for listing these matters along with a series, Lordship, that is.
Along with?
A series is there, Lordship, but the same issue. And that is taken by my Lord Justice Eddie Sodri, Lordship. Tomorrow, those matters are listed, Lordship.
Tomorrow?
Yes, Lord.
Series.
So let this matter also come along with the.
Let it be along
Same
with those.
issue.
Yes, Lord.
Third Mr.
I'm giving. NH Borguya, lordship.
NS.
Borguya.
Yeah, learned counsel for the petitioner and Mr. Nayok for learned standing counsel for
BTC. Lord.
BTC. Mr. Nayok submits that connected matters are listed before a coordinate bench of this.
My lord, this matter may not be tagged with those matters, lordship. It may be listed individual, lordship, because facts are something different, lordship, as per.
Same tax, Lordship, from 1990 to 2015, then from 15 to 2021.
As per instruction, lordship, in that, those read petitions, lordship, they are, the petitioners praying for release of their arrear salary, lordship. But here, lordship, we prayed for, lordship, pensionary benefits as
Same
well
order, Lordship.
as, back
2021
wages,
order.
lordship.
Lordship, initially they were appointed in 1999.
Yes.
2009, they were terminated. 2005, one division bench order was there. They were reinstated.
Again,
However, no posts were there. In 2021, Lordship, 1009 posts were created. They were given regularization in 2022. They are claiming benefit for this period of 99 to 2022, along with giving them the benefit of old pension scheme. Same issue, Lordship.
Okay. What is the number of that?
Number 6020/2017.
WPC number 6020 of 2017.
17.
And accordingly, Mr. Nayo contended that this matter may also be listed along with those matters before the coordinate bench of this court. There is accordingly allowed, places will do the needful in this department.
Obliged, Lordship.
Obliged.
29.
Lordship, I want a week time to file affidavit, Lordship.
You are for?
I'm for Union of India.
Okay. Third, Mr. Learned counsel for the petitioner and also heard Ms. Sharma, learned standing counsel for learned CGC. Ms. Sharma submits that may be granted sometime to file affidavit in opposition. Here is allowed. That's it. After 2 weeks. After 2 weeks.
Then 13.
May I please, lordship?
Well, petitioner has applied for the post of regular headmaster, but through the impugned SCR, page number 71 and except 14. What's happened, the IS has cancelled it without giving any justification. Whereas this honorable court, has already set aside and quashed show cause notice, impugned punishment, and even the direction given by the DSC Assam has been set aside in WBC 2136, 2024. And petitioner has been wrongly shown as disqualified, by not forwarding his SCR by the IS.
For not forwarding his
SCR. SCR is required to be forwarded by the inspector. SCR. Inspector of schools is required to forward the SCR for last 3 years to the DSC Assam, Director Secondary Education Assam, along with the gradation list. But in case of his SCR, it is cancelled. Page number 71. Without giving justification. On the ground was that, though they have not given a justification, as because the earlier round of cases were pending before this honorable court on the day of cancellation, might be the ground of cancellation. But by this time, this honorable court has already set aside and quashed all the proceedings, etc., whatever against the petitioner on account of not having the NOC. The petitioner departmental show cause notice was issued, departmental proceeding was initiated for not having the NOC for procuring his master degree, This honorable court has already interfered with those proceedings, and
yes, madam.
Lordship, will grant me some time because instructions are awaited, your lordship. And your verbal instructions are otherwise, your lordship, because the ACR that has been annexed by the petitioner, your lordship, that ACR has not been has been self-signed by the lordship, by the petitioner. He has himself produced the ACR.
cancelled by the IS.
Cancelled by the IS because the ACR in the ACR recording officer is the in charge inspector, your lordship, in charge headmaster, and at that point of time, in charge headmaster was the IS, and reviewing officer is also the IS, your lordship, and that ACR was not signed by the inspector of schools, your lordship. So let me place the written instructions, your lordship. Grant me some time.
Heard Mr. Protester, learned counsel for the petitioner, and Mr. Musar, learned standing counsel for respondents in. Secondary Education Department.
Yes, sir.
Ms. Musar submits that the instructions are awaited and she applies for letting her some time. There is accordingly allowed. This is the matter after 2 weeks.
Interim order may continue, at date.
Interim order first earlier.
Item 33 for orders. Third matter.
Lordship, two IA has been filed, one 920 and other is 930. 920, Lordship may kindly take up the 928, my lord, first. 928, my lord, IA. It was filed for substitution of the legal heirs of the petitioner who passed away on 7/1/25, leaving behind his wife, Srimati Krishna De, aged about 57 years, and son Shovik De, aged about 23 years.
Okay. Mr. Gogoi, any objection?
No, I don't have any.
No objection. Okay. Heard Mr. D.N. Bhattacharya, learned counsel for the petition applicant, and Mr. Gogoi, learned
E.R. Gogoi also.
government advocate for the state respondent. This interlocutory application is prepared under Order 22, Rule 3 of the Code of Civil Procedure for substitution of legal heirs of the petitioner who suffered demise on 7/1/2025, leaving behind the present applicant, namely Srimati Krishna De, and one son, namely Sobhik De. Where is the petition and the documents present record? Mr. Gogoi, learned counsel for learned standing learned government advocate for the respondent number 1 and 2 submits that he has no objection in the event of allowing this application. We are taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances, this interlocutory application stands allowed. The name of applicants, namely Srimati Krishna De and Sri Sobh De, is substituted in place of the petitioner in the CRP. CRP number 542 of 2024. In terms of this IA stands closed. And second IA?
Second IA is 930, madam. This is for amendment of the cause title, madam. The cause title in the revision petition, some mistake was there. That mistake may be corrected, my lord, on para 4, my lord.
Learned counsel for the applicant, and also heard Mr. Gogoi, learned government advocate for the respondent opposite party number 1 and 2. This interlocutory application is prepared by the applicant for correction of under order 6, rule 17 of the CPC for amendment of the first title of CRPIO number 542 of 2024. Mr. Protasese submits that in which paragraph?
Para 4A, my lord. The state of Assam represented by Principal Secretary to the Government of Assam Revenue and Disaster Management, Relief and Rehabilitation Department, Dispur, Guwahati. This may be inserted, my lord. There is some typographical error.
So this is the correct address.
This is the correct address, ma'am.
Okay. Mr. Protasese, learned counsel for the applicant, submits that in the cause title of the revision petition, the respondent number 1 may be amended as the state of respondent represented by Principal Secretary to the Government of Assam Revenue and Disaster Management, within bracket Relief and Rehabilitation Department, Dispur, Guwahati 6. So Gogoi, learned government advocate submits that he has no objection in relation to allowing this application. Further, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, this IA stands allowed. Necessary correction may be made in the cause title. No, the applicant shall file amended cause title within a period of 1 week from today.
So far, the main petition CRP is concerned. Payment has yet to be received, my lord.
Lordship, the budget has already been allotted, Lordship. But ceiling has not yet to be, ceiling has yet to be received by the DC Kokrajar. This is my instruction today. Today I was called DC.
When you are going to release the same?
As soon as when we received the ceiling, Lordship. That's today DC was when I was called to him. He was in meeting, but just instructed me that budget has already been allotted to get amount, but ceiling has not been received. Whenever we receive the ceiling, as soon as I
No, he may receive the ceiling in the coming year. Or so do you wait till next year?
Because let me total get the total instruction from the DC. After one
Anybody from finance department? Anybody from finance department? No. Who will grant the ceiling?
Finance department.
Then when you have sent the proposal there?
Because proposal already been sent earlier,
No,
Lordship.
that's all right, but for ceiling, when you have sent the letter?
Ceiling
That is,
was
that
negative.
is, Lordship, I am not.
Right? Yes, yes.
Then what instruction you have received?
Lordship, today, over telephone, I was instructed, Lordship. He has tell me that ceiling has not been received yet. Let me get the total instruction from within a 1 week, Lordship.
So 1 week means for how long he will run?
It was in May, February 25, my lord. So for the instruction submitted by the learned council,
24
Mr.
February.
A. Foucault, from GAD department, my lord. Bajaj has been distributed for an amount of 9 lakhs on for 24, 25 in February, my lord. The letter was signed on 10 to 25, my lord. Till that it was the earlier occasion also, he submitted that ceiling was not there.
Okay, let it be the next week. In the meantime, you file the amended post title.
Right.
Director will see if necessary, will direct the personal appearance of the secretary concerned. Partition, protection, learning, so product, and so hard, so learning, sampling, also. Learning, county portal assessment number, learning, government advocate portal assessment number 1 and 2. 1 and 2. Mr. Gogoi submits that he has received instruction that the budget has already been allotted, but the ceiling has not yet been done. For drawal of the aforesaid amount, then he submits that he may be granted some time to obtain up to date instruction. Fair allowed basis is the matter of when next week. 23rd. 23rd of September as part heard. Gogoi, you have to obtain up to date instruction. And you see, if no payment is made, the secretary has to appear.
34.
Lordship, here is the order of 18/1/2023. On direction was page 25, paragraph 16. Direction was given to provide all benefits from the date of provincialization or other teachers. So other teachers have been provincialized from 1/1/2021.
Lordship will see below the instruction. Pursuant to this order, Madam, to kindly first see page 4, Madam, of that complaint. In compliance to the Honorable High Court's direction, Madam, the secretary has passed this order. Lordship will find the order at page 5.
Then why the matter is pending?
Well, thereafter, my lord, the authorities, my lord, the director has written to the universities for verification. And it took a lot of time, my lord, because the university was not responding. Thereafter, by your lordship's kind indulgence, my lord, the senior friend appeared for the university, and thereafter the verification is done. Now, my lord, to kindly see page 1, my lord.
Verification is done.
That it is done in favor of the petitioner. And accordingly, now, my lord, the petitioner, a proposal has been sent by the director for creation of post, my lord, in favor of the petitioner. And that is page 1, my lord. And page 2 is the format for SIU approval along with the area.
Now at what stage the matter is pending?
My lord, it's pending for SIU approval and for post creation by the government.
That's all right, but at what stage it is pending?
My lord, that is page 1. My lord. Proposal is pending before the government, my lord, for creation of post.
Oh, you obtained up to date instruction. This is of this letter is of dated 13th of May.
13th of May. My lord, I've taken instruction, but it's still pending there before the government.
Still pending.
Because SIU approval has to come from the finance.
Yes, Mr. Soliha.
Yes, SIU approval. Not it. We are no, we are not. We are not a party in this.
You are not a party, but can you obtain instruction on how long it will take?
Well, provided they have sent a proposal, Lordship, they can.
No, they have already sent the proposal. This is page number 1.
Page number 1. Lordship, they have sent it to the government, Lordship, maybe. I'll provide the e-file of the finance for the finance department. Whether they have forwarded the finance department, but Lordship, because this is. Lordship will give us 3 weeks time.
As per his instruction, this
It is pending before the
SIU
government.
approval is to be granted by the finance department.
That is their Lordship. Provided this proposal has been sent to the finance department. That is why they will have a copy of the e-file number. Lordship, that is. Lordship will give us 3 weeks time. In the meantime, we'll both will.
3 weeks means.
Milo, 1
too
week.
long.
It will too long, Milo. 1 week time maybe.
No,
1 week may not be completed.
But then 2
Let
weeks.
it be 15 days time. 2 weeks.
Let it be. I'll get the updated instruction.
Okay. You furnish a copy to Mr. Soleha.
I'll add it.
But Mr.
Hammer
Conductor, learned counsel for the petitioner, and Mr. Kosik, learned standing counsel for the conductor. So Kosik has produced a letter. The elementary education director, elementary education department, dated 13th of May 2025, and submits that after verification of the educational qualification of the petitioner,
The letter it has transferred, Lordship, it has not been sent to the finance department. It is been
to
forwarded
the government secretary.
Yes, secretary. Yes, Lord. Proposal has been sent to the secretary. So.
Okay.
13th May.
Proposal has been sent to the secretary to the Government of Assam Department of School Education for creation of a post along with a checklist. For approval of the SIU. And he may be granted 3 weeks time to complete the entire process. Taking note of the submission of learned standing counsel for the
For the sole respondent.
respondent. The matter stands adjourned to be listed on 6 June.
My lord, can it be, my lord, 2nd of June, my lord, because.
After 15 days.
Huh?
After 15 days.
Then, my lord, after 8.
6th of June.
It may
Mr.
be on
Kondakar.
9th. 9th.
9. Okay.
9th of June, my lord.
35 to 40.
Here, the item 35 was listed on
I-5/2025 lawsuit. This item number 35, contempt number 643 of 2023. It was filed against an interim order dated 22/6/2023. In the meantime, the case was already been finally disposed of on 13/8/2024. Against the final judgment, my learned senior friend has already filed another contempt. So this first contempt has become infructuous because already an contempt against the final order has been filed by this petitioner lawsuit and it is pending.
Earlier, my lord, they have filed, some other advocate have filed contempt
Petitioner has
case
not informed my-
against interim order.
Yes, this contempt case is against the final order or the.
I am filed against the final order.
More explain to it.
Uh-uh.
The contempt 643, the item 35 is against the interim order. That case was, writ petition was finally disposed of
Item
on
number 35 is against.
against the interim order
Interim
dated 22/6/2023. The writ petition was finally disposed of on 13/8/2024. Against the final order dated 13/8/2024, the petitioners filed a contempt number 45 of 2025 lawsuits. So that contempt 45 of the item 39 is pending against the final order. So that contempt against the interim order has already become infructuous lawsuit. That's why
So
this,
you tell me the numbers of the.
Interim order
contempt
against
cases
the-
in interim order.
Yes.
the contempt against the interim order, the contempt is 643 of 2023, item 35.
Next.
Only one case now.
And that's and 39 is contempt 45 of 2025 is against the final order. Item 39.
So 39 will continue.
39 will continue. All these analogous cases lawsuit already this honorable court has granted 3 weeks time to get the instruction lawsuits. So item 35 should be closed lawsuit.
Well, the date may be fixed. Well, in there are 3 cases also, my lord, can be tagged. Oh, okay.
Okay, learn it for the.
Sorry, sir.
And also heard Mr. Sisti, heard it also for the. Respondent. Mr. Sisti submits that. This contempt case number 643 of 2023 is directed against an interim order passed by this court
dated 22/6/2023.
dated 22/6/2023, when thereafter the repetition being WPC number 7621 of 2022 was disposed of on high order dated
13/8/2024.
38/2024.
Which is challenged in item 39.
And for non-compliance of the aforementioned final order dated so another contempt case being contempt case number 45 of 2025 has been instituted. And since the main case has already been disposed of, then against non-compliance of the order passed in main petition has for non-compliance of the order passed in the main petition has already been instituted. No, contempt case has already been instituted. This contempt case number 643 of 2023 becoming infructuous and as the signature clause. Taking note of the submission of learned for both the parties, this contempt case number 643 of 2023 stands closed. As the WPC number so and so has already been disposed of by final order. Dated 20.
Dated 13/8/2024.
13/8/2024. And in these petitions, 3 weeks time have been granted.
Already been granted. So let it come after 3 weeks lawsuit.
Well, date may
All
be
these
given,
cases.
Well,
40.
well, another 3 cases are there. Can be tagged with them.
And also hard Mr. For the
3 cases are there, no? That's correct.
60 has pointed out that by order dated 2/5/2025, 3 weeks time has already been granted to the respondent to comply with the order of this court. And as such, the matter may be in the state of review.
Well, date may be given.
Learned counsel for the petition submits that another 3 matter. Here too.
Yes, 3. Contempt petition
matters
number
being-
695.
Give the number to him.
Okay, it's Yes, my lord.
And the same may be tagged with along with this series of contact cases. Here is accordingly allowed, recital is the matter after 3 weeks.
My lord, can we be
In
given
item
date?
35, none appears for the petitioners because the councils are different, Lordship. My,
Yes,
my
yes.
senior friend is not appearing in item 35.
Okay. Then would it be proper to dispose of the matter today?
Because ultimately petitioners are ultimately represented by my learned senior friend, Lordship. She is now presently filing the contempt in the main case.
But she cannot represent the petitioner in this
She
case.
cannot
In that
represent,
case, yes.
but in light of the facts, Lordship can, but otherwise it is in fact, Lordship, there is no relevance of this contempt petition.
My lord, can you be fixed on 4th June?
My lord, on last occasion, no date was given as it is a 25 matter, Lordship, that's why.
I think this
2025.
is, no, my lord, this is a case of contempt. Maybe 25, but I have not been received salaries, my lord. Though our school has been provincialized, my lord.
Okay.
In the year 2021, my lord.
Okay, 4th of June.
Yes, right.
Highly obliged.
41, 42.
May I please, Your Lordship? Lordship, may kindly peruse the last order, my lord. The last paragraph, basically, it is made clear that if there is no compliance of the order passed by this court, it should be off 8/8/2023. This court shall consider seeking personal appearance of the respondent number 1 and 3 for enabling the said respondents to explain as to why the judgment and order dated 8/8/23 passed by the so-and-so could not be complied with. 7/4/2025.
Okay, so final selection list could not be published due to operation of the model code of conduct. As per this inspection I received by him.
My lord, I have been told, my lord, preferably possibly, my lord, there will be a notification today, my lord, withdrawing the code of conduct. So if that is so, the 2 weeks will be from today. So your lordship, in a way, we are asking for 4 weeks time. For publishing the final list and for seeking the sending the proposal for SI report.
On the last occasion, my lord, lordship, this honorable court has observed that if they do not comply with that order, there may be a personal appearance, my lord.
Oh, that's all right, but when the model code of conduct is in
Force with 6th of January 2025.
let it say after 2 weeks.
Yes, ma'am. Let it be after 2 weeks. So that I can apprise the
Or
lordship.
Mr. D.M. Decker, learned counsel for the petitioner. Then Mr. Kosik for the respondent. Contempt notes number 1 and 3.
Well,
Mr. Kosik has produced a letter dated 13 May 2025.
One and two,
Of the Director of Secondary Elementary Education Assam, Kailipura, Guwahati. And Mr. Kosik submits that as the model code of conduct is in force with effect from 6 on 2025, as declared by the Assam State Election Commission. The final selection list could not be published. Then, as per his instruction, the model conduct, code of conduct will be lifted today, possibly. Maybe lifted today, and thereafter the matter will be processed. And the respondent authorities may be granted 2 weeks time. There is accordingly allowed, this is a later matter after 2 weeks.
Lordship, I'm appearing at item number 42, Lordship.
Item number
42.
same matter.
Yes, Lordship. However, I have a prayer to make, Lordship.
Both are same, no?
Yes, Lordship, same
Writing
matter.
out to the same day.
Lordship, the order that was passed on the last occasion, Lordship, that may not be diluted. Maybe after 2 weeks, if they are not fulfilling, that may be considered, Lordship. That much may be recorded, Lordship.
That will always be there, my lord. Your lordship is not.
No, my
recalling
lord,
that earlier.
that will not be always there. If there is no observation, next time they will anyway come with some another plea, my lord.
Lordship is not recalling the earlier order.
Not recalling, Lordship may kindly record that in case they are not fulfilling it after 2 weeks, that order may be considered because
However, it is provided that in the event of failing to comply with the order of this court, the court may consider personal appearance of the respondents on next day.
much okay.
What's up? Date has been fixed.
43.
My lord, contempt matter, my lord. A date may be fixed, my lord.
Take it that.
What's up?
43.
43 lawsuit, I have actually we have filed an appeal against this order dated lawsuit. And I have been given file it. I have been my colleague NJ Kharne, he has informed that he has already filed it lawsuit. So lawsuit may kindly take it after 2 weeks. Lawsuit may kindly grant us some time.
There is no stay order, my lord. I have also not.
No,
I
we have
have also
just filed
filed
it.
caveat, my
We
lord.
have not yet filed caveat.
Yes.
It was filed. It will not be listed.
Heard
lawsuit.
Mr. Sarma, learned counsel for the petitioner and Mr. 64 contempt matter. So 60 submits that as per his instruction already an appeal has been filed against the judgment and order of this court dated.
Order dated 2/24 lawsuits in WPC number 6013/2023.
Serial number 9.
Order dated 2/2024. In WPC number 6013 of 2023 and press for listing the matter after 2 weeks.
And that may be fixed, my lord.
We are allowed to resist the list of
After 2 weeks,
matters.
otherwise it will listing or it will take some time lawsuits. Other if fixed
At
that
least,
it
my
may
lord,
not be
that may be
possible.
fixed, my lord, because I am not receiving anything after retirement.
6 June.
Yes.
44.
None appears for the petitioner on call, leaves the matter after on.
45.
Yeah, please, Your Lordship, I may be allowed to take fresh steps, my lord.
Fresh state
Fresh steps, my lord.
for impleadment.
No, my lord. Notice was not
Okay.
completed, my lord.
Heard, Mr.
H.L. Ashkar, my lord.
Is
H.L. Ashkar.
learned counsel for the petitioner. Mr. Block. The learned counsel for the petitioner submits that he may be granted some time to take decisive upon the respondent contempt. We are allowed to resist the list of matter of third. Colleagues,
Lordship, Dusty also may be allowed, my lord.
pardon? Dusty.
Dusty also may be allowed.
So be taken by registered post with AD and also by usual process and within a week from today, Dusty service is also permitted.
56.
Lordship.
Lordship,
Yeah, some of Lordship.
instructions are awaited, Your Lordship.
Lordship, they're supposed to file affidavit, Lordship.
Some time may be given. Your
They are supposed to file affidavit today, Lordship. And as per last order, Lordship.
Heard, Mr.
Yes, Islam, Lordship.
Yes, Islam, learned counsel for the petitioner and sorry for the respondents in elementary education.
Lordship, secondary education.
Secondary education
Second.
department. And you,
Age paramount for respondent number 5.
respondent number 5. And okay. 5. And for rest of the respondent? Ms. Musar submits that the instructions are still awaited. And press for granting her some time. They are allowed to rest the later matter. After 2 weeks.
2 weeks, Lordship. Lordship, date may be fixed.
30.
Deeply applied.
Item 47.
May it please your lordship. Lordship, as per order dated 4/3/2025, we have taken steps, respondent number 5, through dusty mode, lordship. And we additional affidavit file on 7/4/2025. But respondent number 5 had refused to accept it, lordship.
The service completed.
Yes, lordship.
Third, Miss
F. Begum.
F. Begum, Lord Counsel for the petitioner. And Miss Pedanti for respondent number
1, 2, 3, and 4, your lordship.
1, 2, 3, and 4. As per order of the laws in court dated 21/4/2025, service deemed to have been completed. As the respondent number 5 has refused to accept the notice, dusting notice. An affidavit to that effect has also been filed by the office on 7th of April 2025. List the matter for admission hearing after 2 weeks. After 2 weeks.
48.
Your lordship. This case, my lord, service is complete, your lordship.
Service completed.
Complete, your lordship. Only see office note dated 28/4/25, your lordship.
Madam, you are for?
And for
1, 2, 3.
1, 2, 3, your lordship.
Third is
A. Begum.
A. Begum, Lord Counsel for the petitioner and this thereof for respondent number 123. Order dated 28/4/2025 of the laws in court indicates that service in respect of 4 and 5, respondent number 4 and 5 have already been completed. List the matter for admission hearing after 2 weeks.
A date may be given, your lordship.
49.
Take it.
Lordship, here we have already issued a compact order, lordships. I have already served a copy to my friend, lordship. This is the.
Mr. Teka, you have gone for the.
My lord, I have seen, my lord, they have said our claim is not justified, my lord. So we need liberty to challenge this order, my lord.
Okay.
Just now I have received this, my lord.
Third, Mr. P.K. Teka, learned counsel for the petitioner, and Mr. Assistant, learned standing counsel for the condemned. Mr. Assistant, learned counsel for the condemned, produce one speaking order dated
25/10/2024.
25/10/2024. And submits that the order of this court has been complied with by the respondent authority. Mr. Decker, learned counsel for the petitioner, submits that the petitioner may be granted liberty to challenge the speaking order dated
25/10/2024.
2024. And this writ petition may be closed. Further taking note of the submission of learned counsel for the parties. This writ petition, no, this contempt case stands closed. Granting liberty to the petitioner to challenge the striking order dated 25/10/2024 by filing an appropriate petition.
Deeply obliged, my lord.
The letter produced before the court today shall be part of the report.
Deeply obliged.
Item 50. Item 50, lordship, in this case, lordship, the petitioner has already been given GIS money and leave encashment. And the petitioner has also filed a press case, lordship, WPC number 3209 of 2022, 3209 of 2022, which is pending. So this content may be tag along with WPC number filed by the petitioner, lordship, and both the matter will be heard together, lordship. We have already it's there now for final payment is verification it is at the verification stage, and upon completion of verification, lordship, that will be final pension paper that will be issued.
3209/2022, it is regarding the release of pension, family pension, my lord. The husband of the petitioner expired in harness.
Okay, heard Mr. Protesto, Lord at counsel for the petitioner and Mr. Sisti for the respondent. Mr. Sisti submits that whether the
GIS money and leave encashment benefit has already been lost.
that GIS and
Leave
encashment of the
benefit.
petitioner
Yes.
has already been released. Already been released by the contempt respondent authority. And the petitioner has also filed one rate petition being WPC number
3209/2022.
3209 of
2022.
2022 seeking
My lord, grant of family pension.
seeking family pension. And as such, Mr. Sisti contended that this rate petition by this contempt case may be taken with the aforementioned rate petition. There is accordingly allowed, this shall do the needful in this regard.
That case is fixed.
Please the matter after
That case is fixed on 21st of this month, madam.
21.
Yes, let it come.
It is submitted that the aforementioned rate petition is listed on 21/5/2025. SSL take this matter along with the aforementioned rate petition and list the matter on
21. Apply, lord.
Item 53.
53, I have received this instruction, lordship, may kindly pay with me. It is, প্ৰথমতে এতিয়া মানে তাৰ পিছৰ পৰা তাৰ নামটো ভুল আছে নামটো কাৰেক্ট কৰিব লাগিব চিটেটত অৰ্ডাৰটো পাছ কৰা নাই মোক এটা কপি দিলে মই সুধিলা In first two hearings, she was not appeared. Ultimately, she was appeared, but her name was named in the seated lordship statement is wrong, lordships.
Mr. Sharma, you have sent a copy?
Yes,
I have not seen that.
I am submitting all the documents.
And then let it come on Tuesday. I will go to them.
Ultimately, that name has to be corrected in the board one lawsuit. That verification has to come from that university lawsuit.
Well, direction was issued to appear in the interview. I was allowed by this honorable court. Then I appeared. Now they have taken a plea that my name was wrong in the seated. If my name was wrong in the seated, how I was allowed to participate in the selection process?
Heard Mr. Sharma, learned for the petitioner and Mr. Sisti for the spot. Mr. Sisti has produced a letter of the Director of Secondary Education dated 19/2/2025. And a copy of the letter is furnished to Mr. Sharma, Learned Counsel for the petitioner, and Mr. Sharma submits that the matter may be listed on next Tuesday.
Yes.
So as to enable him to go to the letter.
Yes.
Or this before the court. Here is the court and thereof. This shall leave the matter on Tuesday. The letter for it before the court shall be part of the record.
54.
May I please, your lordship? Lordship, as per order dated 26/7/24, service is completed. And a respondent has not filed their affidavit today. Lordship,
Respondent,
respondents are allowed to file counter affidavit.
This is completed. I need some time to file it. I need some time to file it. Instruction is yet to receive. I think 4 weeks time may be given by the file it.
part is
C. Sharma.
is Sharma, Learned Counsel for the petitioner. So thus,
I'll be paying for 1 and 2, my lord.
respondent number 1 to 3.
No, 3 is UGC. I'll be 1 and 2.
1 and 2. 1 and as per order dated 13/5/2025 of the Logic Court, it appears that service in respect of respondent number 4 and 5 has been completed. As such, recessal is the matter for admission after admission hearing after 4 weeks. In the meantime, Mr. Das, Learned Standing Counsel for the respondent number 1 and 2, they file his affidavit in opposition.
Items 55 and 56.
Please, Lordship. Lordship, kindly schedule the Lordship 13/5/2025, Lordship, the Lozima court order, Lordship. Service was completed, Lordship. Well, the matter, Lordship, the admission.
Heard, Mr.
AK Das, Lordship.
Learned Counsel for the petitioner and Madam Musa Harifa. Item 7 and 9. 7, 8, 9. 7, 8, 9. And Mr. Das. Higher Education Department. Mr. Das. Law order dated today 13/5/2025 indicates that service in respect of respondent number 5, 6, 7, 8, and 9 have already been completed. That Madam Musari appeared for respondent number 7, 8, 9. 7, 8, 9. Since service has already been completed, recessal is the matter for admission hearing.
The date will be given, Lordship.
After 2 weeks or 4 weeks?
Lordship, date may be given after 2 weeks.
After 4 weeks. In the meantime, the respondents may file their affidavit in opposition. Item number 56. Peg method.
Same, Lordship.
Same.
Lordship.
Milord, it's regarding item number 6, Milord. Milord, since my learned friend in the opposite side is not here, the matter may be taken up on Wednesday as part heard matter. Milord, the judgment referred. Milord, it is a par incuriam, Milord. On that aspect, I will argue, Milord, on that day, Milord. On Wednesday as a part heard matter.
But
I have some judgments, Milord.
in the matter in which Mr. Buragohai appeared.
No, Milord. Milord. That was item 5. I am on item 6, Milord.
Okay.
So matter may be treated as part heard. Matter may come up on Wednesday. Only regarding that judgment, Milord, whether it is par incuriam or not. whether the relevant laws has been discussed or not, my lord. So in presence of my learned friend, my lord, I will,
No, but did you inform him?
my lord, I informed that that matter would be taken up.
Yeah.
But he left the court, my lord,
But then, okay.
on Wednesday. Most of lights.